I will pass on your
Pass on the memo.
leave the plea.
Yes, pass on the memo. Is it appearing in the list?
Yeah, no, it does not appear.
Pass on the memo.
Read petition. The input order which is on challenging this appeal has appeared in the list in item 14, sub-item 2.
So let us see if we can read. Yes.
There is attachment.
Next,
Pass on this. Pass on the memo.
This appeal may be.
Yes, we'll try.
Maybe my item 40.
Oh, bless.
Now item 4 and 5. This is single.
Same matter.
Mine is 2, sub-item 2.
Yes.
I mean 4, 5.
It's not difficult. If it is called, it's called.
My lord, this will be deleted because this is single bench matter.
Let us consider at the time of call. Pass on.
Lordship, withdrawing the item 14.
Yes. Yeah.
Okay.
One, I could not get it. Keep it tomorrow.
Item number 1, tomorrow.
Tomorrow.
Item number 2, sir.
I will dictate tomorrow.
1, 2 more, sir.
More submissions. Make your submissions tomorrow.
Yes.
Your counter para 12 is very clear.
Rely on that. When I will dictate. Don't know.
Second notice.
No.
If I reply.
Allowed to supply this one judgment which is very much identical to the issue in hand.
Item 1.
Give it.
Item number 2.
May I please report? In this case, the petitioner is a works contractor. After the work minute, as per Annex 9 series, I have submitted the bill. This is the RA bill minutes, which is pending with the authority. Annex 9 series minutes is my application where I have given the bill minutes. At Annex 12 minutes, the superintending authority, who is the tendering authority minute, he has also written that my bills, regarding my bills, the documents is to be submitted at Annex 12 and Annex 13 minutes. Despite of the fact minutes, they have not taken any action. Even they have not released the release.
We will not direct you to consider representation here and now. Take instruction. This instruction. 1 week.
Your annexes?
Minutes, Annex
12, 13, 9.
is my bill. Annex 10 and Annex 12 is the recommendation of the superintending engineer.
Yes.
With regard to annex 9. Inspection is with regard to 9, 12.
Item number 3.
This is the PI matter. The PSC was sanctioned in the petitioner's village matter. And the
What
work order
was
also
sanctioned?
issued.
What was sanctioned? What was sanctioned?
PSC, Public Health Center. And the work order was issued in favor of the opposite party number 1 minor.
Yes.
Now he is going to construct in another place minor. It is the 4-5 kilometers from that place minor. Your lordship may kindly see Annex 3.
Yes, that is an application.
No, that is the order. Earlier we approved this honorable court, my lord. Honorable
Yeah.
court directed to consider. They considered, my lord. And sanctioned 97 lakhs rupees. Had Annex 4, my lord. Relevant page is that which 33.
So they have not considered or considered
Yes, they considered and sanctioned 98 lakhs rupees, my lord.
at that site.
No, on that side, my lord.
Yes, then
But now
where
he is going to construct in another.
what is your reaction to it? Why you are constructing in another site?
First time.
When the copy was served on you?
And the registry received it on copy received it on 14th. And it's what
We are in
But has been.
We have crossed 14 July, I think 2 months.
Yesterday only.
Then why it was not allotted? Must have been allotted to somebody else.
No.
When the allotment comes, as and when the matter is listed, then the allotment comes. Why not be earlier?
Once the matter.
Immediately after the matter is or the service is affected.
Once the list is out, then only.
Should we make some observations so that it will expedite the entire thing? We are making an observations.
Whatever it is. Government advice.
Office, my lord's office. I love.
What office? What office?
At whose instruction?
There's a team which allots the matter, my lords.
Who are the members of the team?
Officers of
In an office.
Who?
That is either government advocate allots or any office staff,
office staff.
staff allot.
Who is the head of the office? Who is the head of the office? Who supervises the entire office affairs?
GA. Government advocate.
Who is the government advocate?
Mr. CORAM. AC CORAM.
Call him. Call it.
You ask him to, he will come.
Just wait, sir.
My item number 4.
Proceed because of that. It will take some time.
So we are proceeding with another matter.
Item number 4.
No.
Please wait.
Pass.
Me appeal also. And this is an application for the interest of the public. From 12 to 20.
Who?
Now the passenger, Cutoff Palasa passenger is going on 12 coaches.
12?
Coaches.
Passenger of the Cuttack is going on.
Cutoff Palasa passenger is going from Palasa to Cutoff and Cutoff to Palasa,
Right.
having 12 coaches, bogie.
Okay.
Now, though the public are in difficulties, facing difficulties in manner, that train is continuing each and every station are halting, each and every station, local station. That therefore I pray, my lord, the coaches solutions and extension of coaches, my lord. 12 coaches to something.
Additional coaches you want to be directed.
My lord,
Additional coaches to be
Yes.
added to the train.
yes,
You want a direction from this court.
my lord. That is why I filed one representation before the office.
Show us our powers to pass such an order. I am ready to give. Show us our powers.
Because one representation is
In a public interest litigation, we can really run the administration. We will direct them what to do, what not to do, how to run the office, how to man the office, how to do it. Tell us the PIL. One judgment, I will be happy. Of the Supreme Court, give me one judgment. That we have the pass, High Court can, we are ready to pass.
My lord,
Show us the law. I must be very candid and very frank that I do not know about this law. Please enlighten me.
that is not my point, my lord. One application is pending that we considered.
I have a strongest of reservation on a direction upon the authority to consider the representation. First thing is, if you have a right, then I will decide here and now that
I will show the judgment
show us any time you want. Tell me
after 1 week, right?
1 week,
After
please.
You tried during vacation.
Yes, my lord. I
Still
tried during vacation. My lord had pleased to put up this matter before lordship.
Put
Put up this matter before lordship. I tried my
because he knew that what would come.
only my now the
Only Sir,
It is covering my lord.
it has a larger ramification if we interfere in all these matters.
260 kilometers it is running.
Sir, whatever is, how many number of coaches, it all depends upon the capacity of an engine, how to run, everything we will decide. These are all the technical issues. We don't know what is the track can withhold that particular load of more than 12 compartments. We don't know anything. And we will here sit and pass a note.
That is
why we are an expert. We are a mechanical engineer. We are an automotive. Every engineer we are here. What are you talking about, sir?
Our application is pending. That is my innocuous player.
No, sir.
Okay.
That is not a PIL, sir. Then it is not a PIL. For consideration of the representation of PIL, show us any judgment authority on the point.
One week after I will try myself.
Give you time.
Yes.
Give me a date when you can.
August 5th, my lord.
August 5th? 5th August, yes, no difficult.
My lord is adjourning this, sir.
5th August, sir.
Oh, great. Yes, sir.
Item number 5.
I mean, he's in the. He's not.
Next bill.
Yeah, public interest litigation by some of the villagers of the particular village of Jagatsingpur. This concerns about construction of a multi-purpose cyclone and flood center. There are some.
Is the cyclone prone area?
Yes. In fact, in 2021, in fact, 2020, 2021, 2022, the collector, by making a necessary inquiry from the council and revenue, he has recommended for.
This is a bare necessity. That if it is a cyclone prone area, then these persons who lives in a thatched hut, sometimes they need.
There is government has already taken step in this matter with us. I have obtained instruction. I also need to obtain further instruction in this matter here.
To do one thing, sir, because this is a public interest litigation. So you file your affidavit, not counter affidavit. It should be an affidavit that should be filed, disclose the steps and what more can be done. Right? The important issue.
From here it is around 45 or 50 kilometers. From here it is 50 kilometers towards sea.
Please file it. Yes.
Item number 6.
And in this matter, we are filing counter affidavit in force of the day.
What is this?
You also directed on Richard 87 to the complaint for filing.
Whether a page was there in the,
Huh?
whether a particular page which he says that
Okay.
along with tender he filed,
Oh.
page 37,
Yes.
whether that was available in the,
That is the only very small question. What you have,
you are only to show from his uploaded documents that whether this page 37 was available or not. That is the only issue.
Today we are filing.
Already twice, madam was taken.
For the last matters, today actually, for the day, we are filing affidavit.
sir, affidavit for disclosing the only fact whether this page 37, which he has annexed, forms part of his tender document.
We are simply to download that, take a printout, see whether page 37 is available or not.
But I may pray for a password. I think it's the task.
That is the only order, you see.
We appreciate that it is good for you to draft the affidavit and file the affidavit, but the issue is very small.
But today,
If it does not form part of the tender document, matter ends. He has no locus standi to stand.
but today, not to take up this matter tomorrow. Today, we
Tomorrow, come.
The last question, you had the instruction, but that was not in consonance with the requirement of order. That's why we adjourned today. That is the only simple issue.
like
Item 7.
interim order kind of.
Next date, yes.
7.
In this case, the petitioner is a UC, as per the needs agreement for London 1222, she
42.
22. He applied to execute the leave for a period of 5 years. But after 1 year, on 10th October 2023, the transit pass has not been issued and rejected on the basis that SEI requires the amendment of the mining plan. Considering the location and situation of a bridge near the mining area, SEI instructed to amendment of the mining.
Sri means?
Sia.
State Environment Impact Assessment. The amendment plan has been submitted. Thereafter, again, the same was written, again resubmitted. For that 1 year period, financial year 2023-24, I have paid the royalty in advance, but could not operate the slot. I made an application to adjust that royalty for this year. My application has not been considered. Time and again demand notice has issued by the mining officer to pay that dues instead of allowing me to operate the source for that period.
Till date, they have not sanctioned the
No.
modified.
No matter that recently the amendment mining plan
Approved.
recently
Recent.
by reducing that area, reducing the original area, the amendment plan has been approved. Only my prayer before your lordship,
He wants adjustment of royalty. I'll have to take instruction from the authorities.
Well, what he is, Rivas, if I understood is that he was not at fault. He was directed to submit, he immediately submitted because there was a bridge nearby or there was a flyover award.
Yes. Nearer to the has brought that approval, which he has enclosed to. So I'll have to take instruction. Whether that royalty which he has already paid without operation, whether it can be adjusted for 25, 26. So I'll have to get that instruction.
You take instructions and then receive an order from the court. When?
2 weeks time. 2 weeks time. So that
Again, he's saddled with the responsibility. Take it. Only the instruction has to be taken.
only I'll get the instructions by
So why 2 weeks time?
weeks time maybe.
Take it.
Fact is, you have to assess the fact whether actually he operated during
Yes.
that period or not.
Or not.
And paid
But that-
during that period.
Yes.
True, that is the only thing. On his prayer, 1 week to take instruction.
Pardon, madam, item 3, your lordship, regarding the VAC location and all that. So on 14.5,
Sir, there are two things. That's a request from the bench.
No.
May I please lordship? Still, State Council taking time to obtain instruction. Yes, sir. Time was taken by the State Council to obtain instruction. This matter
Here I
related
have
to setting of
instruction.
onshore.
I have obtained instruction. His specific prayer is that his application for shifting has not been considered by the authorities. But fact is, for 2025-26, his license has not been renewed for non-payment of dues. Unless the license is renewed, further application for shifting, it cannot be
Lordship may
done.
see.
Lordship, I kindly have this instruction.
And my lord, once shifting is effected, license is always renewed in respective place. That shifting is allowed, for how the license will be renewed. Because it has been kept pending more than 11 months.
Let me understand.
Lordship may see the annex one.
Please consider shifting is what? There is an existing shop, online or offline, whatever. There is an existing shop situated in a place A. You wanted to this shop to be shifted to
Yes.
place B.
Yes.
So whereas all the conditions of the license is concerned, it will carry to a new place, that's all. Because the license is, if I correctly understood, license is to operate at a particular place. You cannot operate as per your choice, any other place.
No,
on the
yes,
basis
your
of the
lordship is
license.
right.
Correct.
Correct.
So what he says is there must be a subsisting valid license.
Lordship may
As on
see.
the date, if they say shift, they are not supposed to give you a fresh license. It is really only the amendment or a modification is to be made by changing the address,
Place.
nothing more than
Yes,
that.
place and plot. Place
But,
and
but
plot.
your obligations, so far as NGQs are concerned,
Yes.
your obligations towards the payment that remained with us.
That is-
What he says is to some extent that it appears to be logical. That unless the license is renewed and this is a subsisting license, you cannot shift it.
Lordship may see the annex
You
one.
cannot shift it.
My
Lordship may
license.
kindly see that instruction.
The copy
Para
of the
10
license.
onwards, your lordship may kindly.
My license was valid till 31st, my lord, August. It appears on the, my lord, the license at page 10. On 5/8, I submitted online application along with the statutory fees of 2.5 lakhs.
So 7 is your instruction.
Yes.
And 7 is only your instruction.
Yes.
Annexure 7, the contents of Annexure 7, you have submitted that.
I have given that.
Huh?
Course, that is there. Para 10 onwards, if your lordship may kindly have a glance of that instruction.
This is a reflection of
Yes.
NHS 7.
Yes.
Then why on instruction? You would have highlighted.
Last day also, the lordship
had directed.
posed a pertinent question because my license was valid till 31st August 2024. On 5th, 8th, I submitted online application along with statutory fees of 2.5 lakh and the land particulars. Then there is a delay near about 11 months at their end, man.
I understand. Has it been supposed? Let us understand for the purpose of. You applied 24 days before or 25 days before the expiration of the license. Suppose if they expedite and within 10 days, they shift. Then you have to operate from there.
Yeah.
Then you have to get that
Yes.
license again.
Yes,
now the next.
Yes,
Why don't you get it removed now?
now, my lord, what they have said, my lord, the
Yes.
area, unless that area,
You can't, they're dues.
my lord, I
You
can't
use.
accept, my lord, also may see, it could have been done within a 4-month, the statute says. From the date of submission of application could have been done.
For that, we will definitely
Because
canvass them, we can put,
my
put
shifting
them on
application-
terms, whatever. But what about your obligation of payment?
My lord, I am bound to pay. Lordship may see, my application could have been accident.
We will say that
My lord,
within 2 weeks.
They have called for the unlicensed period, my lord. Because 1st August, the shop is closed. And now they are directing me to leave the executive.
Sir, just tell me, let me understand, sir. Was there, or whether they compelled you to shift?
No, that was because they have.
Whatever, that was your choice, you made an application voluntarily. If you decided to shift, why you will put a blame?
Only one thing. Lordship may see Annexure 6, only for a moment.
No, this financial year, if you get it renewal, you will have to live.
Because it could have been done within the March. Then it was easier on my part to leave the MGQ. There is no question of area. Because delay and losses on their part. Now still it is paid. Lordship may want to go and pray.
Sir,
Tell
was
that-
there any impediment in continuing your shop at a particular place even after you make an application for septic? Could have.
Lordship may fix it.
There was no order passed by them not to operate.
That amount I will pay in 2 installments, my lord.
No,
First, that's the minimum. I will deposit 5 lakhs. Thereafter,
you can't bargain with
no, my lord, this is
You can't bargain.
difficulties because
This is not appreciable.
since 1 year it
It's a
is
thing of the statutory responsibility, liability, know your bona fide by deposit of the money. No difficulty.
what will happen, my lord? See, again they will demand from 1st April to till to the pay the.
Sir,
That is the
sir,
difficulty.
first you show your bona fide, don't apprehend that what they will do and what they will not do. Don't apprehend this.
I'm bona fide,
But unless there is a valid subsisting license, nothing cannot be done.
Lordship, direct, then immediately they will renew.
Make the payment.
That 10 lakhs will pay, my lord.
Pay. How soon? Tell us. Tell us.
Within 15 days.
What
They immediately.
Yeah. Give the yes. An application for shifting. The
I made it clear to final application amendment. And final application for amendment manner that may be considered, and I have also submitted the consolidated application. Maybe accepted.
I could not get it, sir, to be very frank.
Yes, my lord.
No, the
I have some-
application.
No, I have not received, my lord, but I've seen the amendment application here. My lord, respectfully,
You have got
No, my lord.
motion for amendment?
no, my lord.
No.
Not there in the record, but I've seen it in the this.
You want to also?
My lord,
He has already filed
no, my lord.
in anticipation that this consolidated.
Consolidated split application.
Have you got it?
I've seen it, my lord.
No, no, no. Have you got it?
Copy I have not received.
Sir,
And present.
Have you seen it? Where is the schedule of amendment?
Schedule of amendment for the.
Where
Just I have added one paragraph.
it is, where is that schedule?
Schedule is at page 4 of the IML.
What is that?
At 4,
Oh, that is at the bottom.
toward the bottom.
Oh, this is the minor one, yes.
My lord, I may,
Yeah. Correct. That is to be allowed. This is an application for amendment of the regulation. Incorporating the facts which are intertwined and are interrelated with the facts constituting the cause of action in the instant execution. The amendment is formal in nature and we can dispose of
yes, my lord.
without insisting for that.
Yes, my lord.
With why you.
In this case, your lordship, my pardon, I appear for opposite pattern number 4. The selected person, I have already tried out of power.
So have you been added?
I'm there, already there.
Already.
But notice was not issued.
Notice was not issued. So if he serves a copy on me,
Means,
I am sorry.
was it communicated? The date was communicated.
postponement, your lordship. Yes, my lord. 9/6/2025.
There was a notice, the subsequent.
Yes, yes,
There
please.
was a subsequent notice of 9/6, which fixed the lottery opening date at 10/6, my lord. And the representative of the petitioner was also present, his
On
signature.
10/6.
Yes, my lord,
Yes.
and his,
When the entire decision was taken on 10/6.
yes, my lord, and his representative lottery was opened, my lord.
But that's true, what it was opened in his presence.
Yes, my lord.
No, madam.
I maybe
He has signed,
That's good.
particular
He
letter.
was not present in the lottery.
Let us see, that your client may not divulge the true fact. You are the creature of the instruction.
No, madam.
You're not.
Yes,
What are you
I am the creator of the
So
instruction.
now you're in the
You're not
creation of the
very
instruction.
But
If it does not instruct you, what you will do?
yes, ma'am, very active.
Let us see.
And it's the
What is
first,
his name?
board's construction, my lord, the first flag, my lord, if I may record, first flag.
First.
That is the notice dated 9/6/2025, my lord.
Sorry.
And Bose construction number 2, my lord, serial number 2. Where the notice has been sent for
Serial number?
2, my lord.
Second tag.
Second, Bose construction.
Yes, serial number 2 is Arun.
Oh, my lord, it's, first flag, my lords. 9/6/2000.
Oh, his both construction,
Yes.
proprietor Rahul both.
Yes, ma'am.
Then where is the?
Next page, my lord.
Yes.
Third, my lord, Abhijit Bose, he's the representative of,
Abhijit Bose.
Yes, my lord.
But Rahul Bose is the proprietor.
My lord.
Rahul Bose is the proprietor.
Who is the Abhijit Bose?
I don't have the instruction. No, ma'am. No. He's not.
Your brother?
No, ma'am. He's not the authorized representative.
As per,
Don't be so
I will
diplomatic in your
take
answer.
I will take
I am
instruction.
asking this. Who is he?
But
Your
he's-
surname appears to be same.
Same, but he's
Why-
certainly not.
why asking your brother, your son?
But
or-
he's not the proprietor of the farm. ma'am. And
Nobody on the earth can be a proprietor of his father.
and so far as notice is concerned, no notice.
Is anybody a proprietor of his father? No.
And no notice was also given.
That events.
That they let them file a counterclaim, but I will take instruction.
Immediately go out and call on this number and ask him who is he. With the,
and it's in the para.
Yes.
that will do.
Yes.
My brother correctly said, they have the document so far as the previous date when the lottery was fixed.
Yes, my lords, that is also there in this
Yeah,
document, my lords. It is page previous to 13/5/2025, my lords.
Yes, really.
It was initially to be fixed on 25, my lord. My lord, the first flag before that was, my lord.
Before that,
It's also there in the repetition, my lord.
I just wanted, then on that day, everybody has appeared.
Yes, my lord, the tender committee meeting is also there, my lord.
Oh, then this must have been there,
Yes, my lord.
sure that to appear.
My lord, if I may refer to
The
second
Where
flag.
is the attendance sheet
Yes, my
of
lord.
earlier date? Before
Earlier-
10/6.
No, my lord, but it was not held on earlier date. On 10/6, the next page is the
The
attendance.
intimation was given at the spot that today it is not going to be held.
That's what is the letter also indicates, my lord, that I am to intimate that the tender of the following project, which is scheduled to be finalized on 25 at 10 AM in the office, is postponed due to unavoidable circumstances.
Lottery on 10th was not never issued to the present petition. ma'am. On 10/6, they say that lottery was conducted, but for 10/6, no notice was ever issued. I have not issued any. And the person who is selected is outside the district, completely is a outsider, madam, and deliberately with a political intention. He is from Jajpur, and the work is at my lord, Nuapada, which is 500 kilometers away from the place, my lord. And he has been dragging to, and he has been entrusted with the work, my lord, with a motive, and that is dealt from the communications, my lord. No notice ever was issued after this 25. Thereafter, no notice was issued for lottery.
Madam, when you have written something, then your authority must also annex the copy.
My lords, in the.
I have seen paragraph number 9, your comment. And it is a very, 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 I would say, startling difference.
And it's the petitioner's brother was present, that's not. Yes, my lord.
There must be a earlier document,
Yes, my lord.
one document prior to 10/6. You have produced a document of 10/6.
9/6, my lord.
Lottery was held on 10/6.
Yes, my lord. And the note.
So that attendance is of 10/6. When it is present, the lottery was held.
Yes, my lord. Yes, my lord.
I'm asking you a document prior to 10/6.
No, I-
Where in your comment you have indicated.
My lord, the first flag, my lord, that is the notice of 9/6/2025.
Obviously, you are not getting, that's the whole problem. Because you have not read the instruction. Have you read the instruction, paragraph 9?
Yes, my lord.
What it says? Your authority?
Opposite party number 3 has issued notice letter number so and so dated 9/6/2025. An intimation was issued to all the participants, including the petitioner, regarding finalization of the
Correct.
tender on 10/6/2025. Accordingly, the authorized representative of the petitioner, Shri so and so, was duly participated in the tender finalization process on 10/6/2025.
Correct. He wanted, when you say so, anything which is prior to 10/6, the same thing he appeared for accepting the notice.
That is all.
Because there were 2 or 3 dates which were fixed for lottery.
Yes, ma'am.
Then each day must have been communicated.
Yes, ma'am.
Is the document of communication.
Similar,
He is denying. I do not know, I do
Yes,
not
ma'am.
want to make any comment on that.
and similar notices were issued, but no proceedings.
He is disowning his own brother. What can be done?
And as per the
You
condition,
don't have any other record to show. That's
Trash it here and
the
now.
proprietor has encouraged his brother to appear representing. You have just indicated in your. Merely because somebody represents, comes forward and say that I am representing him without authorization, can you?
unless I'll ask whether any authorization was given on that. day.
Time is.
Show us one document. That's enough prior to 10/6. And we are recording a judicial recognition or recording of your statement.
That no communication was made.
That this, the gentleman has no nexus, no connection with you.
I
Not
didn't-
related, he has nothing,
were
you will
my-
just record your submission.
Well, my humble submission is, the said, boss, what is his name exactly? He was not authorized by the present petitioner to appear for him in the lottery. That your lordship. You are not authorized. And it has been done in a surreptitious manner, my lord. They have not conducted lottery. They have simply, in order to select opposite party number 4, they have done everything. They have also brought the addendum to the original notice in order to select it. They have done everything. That is mine.
Yes. Let us see.
Oh, yeah, my lord, your lordship.
Let
Definitely.
us see
But the,
how truthful and trustworthy the petitioner is. Let us see.
Item number 10.
Please, your lordships. This is the second round of litigation. Petitioner is a junior commissioned officer in army and is due to retire in 5 months due to the non-implementation of the lordship. The petitioner is
This is the second round of petition in army.
an army.
Of
And
course.
in junior Naib Subedar rank in a junior commissioned officer. And lordship, due to the non-implementation of DOPT orders and deputation, there is a order of DOPT that in the last year of service, the armed forces personnel will be inducted into the civil ministries through deputation so that they can continue on re-employment thereafter. So due to non-implementation of this memorandum into any of the recruitment rules, the petitioner approached this honorable court in 2022 by writ petition 1388 of 22. This honorable court had ordered dated 20th March 23 directed the DOPT to look after the grievance of the petitioner and include those provisions so that he can be inducted into the
Include those provisions.
include the provisions of 1986 memorandum, your lordships.
Okay.
Then there is nothing been done yet, and the petitioner is yet to retire within 5 months, your lordship. His discharge order is already issued and NOC is handed over to him. But
Sir, who is appearing? DSG, learned DSG has to appear.
Well, let's see. We are appearing, man.
So,
Well, they have challenged the policy of the DUPT in paragraph 12, let's see for a moment. And
in earlier round of litigation, what he says, there was already a direction.
Passed by this court
my lord,
to do a particular thing. He says that till date, nothing has been done.
I'll take instruction then.
And he's going to demit office or going to be removed from office or whatever. Discharge from the duties within 5 months from date.
Let's keep it after 3 weeks. I'll take.
actually, one more thing. There is a recruitment goal is having a general policy by the office number and head office number and so and so. We direct the opposite party number 1 to consider the requirement. Is also planned by the uniformity and was that is pursuant to such policy shall be sent of consideration at the time of disposal.
So representation has been disposed of.
Last or actually not good one. Down level. It's sort of
No,
There are such representations if not for incorporating this in the as a force
Within 3 months. So take instruction within a week.
Yes, ma'am. Yes, ma'am. I'll take instruction.
Let them take instructions within a week. This is the matter in the next week.
Let's give some more time. After 10 days at least.
With respect to directions contained in Annex 12.
Yes, my lord. A little bit more time. After 10 days.
Then communicated or what? Please tell us. 3 months time was given to you to consider the representation.
I am obliged, my lord. Definitely, I will take the instruction. Let's give a little bit more time. Then.
Give next week. Next.
Item 11.
Blessed.
No, my prayer is your lordships would see, because though the allotment of the land is completely done in.
How can you declare that it is a government hospital?
My lord, the reason there is a.
How? Under what provision?
No, my lord, why I have filed, I'll just point out subject to your lordships. There's a guidelines issued by the Supreme Court, where when the land is to be given to a private party, then what is the procedure to be followed? for the purpose of either setting up of a hospital or a educational institution or anything by the state government. So here what has been done is state government predetermined that it will be given to this society, this hospital. And or for that purpose, like without following any procedure and without any notification, land was allotted. So we have no, since it has already been done, so we can't now turn back the clock. But though it may not be possible to declare it as a government advocate, but the government should ensure that the underprivileged and the BPL card holders and all these people can be treated because it has been taken for a public purpose. If your lordship grant me 2 minutes, I'll just show certain documents why it has been done. If your lordship may come to page 57, just for a moment, that is annexure 4. Your lordship's call.
Yes.
If your lordship should read just the one line.
They
above.
say that it was allotted to NH, but anyhow they are lying vacant.
Lying
We do
vacant.
not want this department for public purpose, want that.
For public purpose. Prior to that, if your lordship should come to page 49, that is a document which is the decision where it was the first recommendation. It starts from about page 44. The recommendation of the land allotment committee. That is
49?
meeting dated 6/5/21.
Page 49.
Yes, 47. I'm sorry, my lord, 49.
Yes.
The first one.
It
Serial
is
number
inverted one.
29.
Anyhow, huh? Yes.
Serial number 29.
Yes.
It was deferred. The first committee, when the land allotment committee sat, this proposal was taken up by the committee. They deferred it. They didn't give any reason. Then, my lord, the second proposal came, which was on 26/8/21.
No.
Page 55.
You are coming under what? Nakhara.
Not Khara, my lord. That is the
Not
Moja.
Gotikia.
No, my lord. The second one, Nakhara.
Nakhara.
And the land is supposed to be this Nainjori area,
Yes.
which is adjacent to the highway, in fact. So lordship should come to page. This was the first recommendation which was deferred. Then your lordships may come to page 55. This is the second recommendation. That is dated 26/8/21. It starts from my lord.
Yes, they says that it should be allotted in your favor.
Not
on-
my favor.
What is this Shiksha
This Shiksha
Anusandhan on relinquishment of the same by the Works Department with the NOC from NHAI.
Yes. So this was, my lord, pre-decided. And then the purpose, the letter was issued, which I showed to your lordships for some other, they write, some other public purpose. And after the allotment has been done.
Where is that? Which page you just referred?
My lord, 55 your lordships. Yes.
55.
Yes. On the remarks column.
No.
Recommendation.
This recommendation is such and such will be allotted in favor of Shiksha or Nusandhan on relinquishment of the same by the Works Department with the NOC.
NOC from the NHA.
That's all.
Yes. Then, my lord, they write to NHAI on 31/8.
Where is that?
That is at page 57, my lord, which I showed at the first instance.
Yes.
Annexure 4.
Yes. Then,
my lords, the NHA granted to use up 2.07 hectares and all for public purpose. And then your lordships may come to page 60.
It was solicited approval for transferring the said land to the state government Odisha.
Yes,
So it was transferred.
it was transferred.
Then
Then the lease has been allotted or the land has been allotted to this private organization, the Shiksha Anusandhan, which is the owner of the hospital, private hospital.
yes,
And on the government land, government has allotted it at a, like whatever their reduced prices and all. And to that extent, my lord, your lordships may see, your lordships may just for a moment come to.
I understand everything. I am just wondering, please tell me that whether these kind of affairs can be entertained
That's why, my lord.
and the court will say that treat this hospital as a government hospital.
My lord,
Can
I
it be?
understand. That is why, my lord, I toned it down.
I
saying
understand that it was for such purpose, whatever they allotted you, you are running the hospital.
No, not me.
No.
my lord. I'm not the owner of the hospital.
It was
I'm,
allotted.
I'm for the organization which has come up against this hospital to say that the government should take care that the
Oh,
free treatment is given because the purpose for which it has been taken, that is not being fulfilled by a private entity. Because everything has been done, Lord, I have given the illegalities also in the process, where without notification, without the permission of the sub-collector, where more than 1/4 of acre land is to be allotted, then the Supreme Court's guideline regarding allotment of land to private parties, Lord, everything has been violated. But all said and done, my Lord, if they have set up, they should also come forward to give proper treatment to the the deprived class of the society or the poor society, like they get
You
from the
are-
hospital.
you are
They
a
may earmark
you are a Bhuvaneshwar Unnayan Parishad.
Yes. To that extent, I'm not saying, my lord, to cancel the lease or not to allow them to run anything.
Can it be done? I'm asking you very simple,
Like-
sir. You
like
are
the government.
you are moving a writ petition so as that the writ court can go that far.
My lord,
If the government land was allotted to a private entity without following the guidelines, without following the procedures, it is a government who has to either cancel it or to do whatever.
since
But
the
now the
government has
question,
done it,
that is why,
obviously.
if it is for a larger public interest, when you are aware, then you'll have to.
No, Lord, I simply, what we pray that a part, they may also, they have their own treatments, everything they cater.
Can there be a policy which is by
It
an
is-
order
it
of
is-
the court?
It is there, my lord, of the state government, where the hospitals are required to give.
Only
the
thing
private
is,
hospital.
that is if they have come out with the policy, they have issued a circular or a memo as required under the law, then every hospital has to consider it.
Lord, that is not being done. That is why the present,
So
my lord,
why,
the
where is the obligations? If they say we have set up a government hospital here for all these weaker section of the society, they can come. Then why every hospital has to be
No,
considered?
not for all. There is a percentage of the treatment which is to be done for free or under the different schemes of the government.
You just say that those schemes have to be implemented. What are those schemes?
Lord, this for the EWS people, the Lordships knows that old Ayushman scheme and all these schemes where they get the free treatments and the government bears the cost.
No, I understand because I also am aware from there, Swasthya Sathi, there was a scheme where the government has given up to 5 lakhs, of rupees in any hospital. If you want, the government will be that
Yes.
is kind of a medical.
That is
Like
also
it is
here
given.
in Orissa. That is also here in Orissa. So that can be extended also.
So it is extended. It is uniform to all.
No, my lord. The problem is they are not following it. The government has
That
to
is a
ensure
different.
that.
Show the instances that they are violating. The government will definitely take care of that. If they violate, it's the government who has to take care of that. How can we pass such an order? How can we pass such an order?
Section 9 is the lease deed executed in favor of that institution, and that is the registered lease deed. And in lieu of premium of 15 crores, well, it is not that free of cost the land has been given. Violation of
5
all
acres.
rules and regulation, everything has been done.
His endeavor is to see that government should ensure
Yes.
free treatment to the weaker sections of
The society or whoever.
My
my
lord,
lord,
government has issued health cards.
that institution.
Your lordship may kindly appreciate. My lord, Government,
Yes.
government has granted health card to all the poor and privileged class everyone. Now, these private hospitals across the state, they are accepting those health cards. And those are the treatment basing on that health card.
So let them say, my lord, that this hospital is also covered under
Yes.
that and for the public
Saying
purpose.
that it
accepting
was
health
not a
cards.
free of cost, they have taken a premium.
No, 15 crores, my lord, on the highway of the Cuttack
Sir,
Bhubaneswar
it's not
for
same.
5 acres.
It's not
If-
same. Please consider, there is a vast distinction between a out and out sale.
I understand,
lease.
my lord.
The lease has a duration and after the expiration, they are put at risk.
And if your lordship should see the lease deed.
What is the duration of the lease?
This is for 90 years. Which is as good as.
Long term,
Long term.
yes. We are not going, whatever is there, the premium and all, everything that they will.
No, your lordship may simply say that the government will ensure.
No, it's not ensure. Let them come, they have said that everything is, put it on affidavits.
Yes,
so
my lord.
that you are, that's being uniformly followed.
That is good enough, my lord, for us also. That's good enough.
Though the manner in which the relief claims in the instant publicity is the petition is found. Does not
supply of diets to indoor patients. The Lordship Commission, this is a case where there is a blatant violation of the requirements of the government guidelines. And there's a tender conditions have been tailor-made and fixed in a biased manner to favor a particular party. How I'll take for Lordship. State and the hospital is there.
Opposite
Hospital-
hospital minor.
Hospital is number one.
Opposite party number. It's the institute who has quoted the tender measure. The necessary participation.
Notice on them and then come back with this one.
My lords, the 19/7, the last date of submission of the bid. So that will keep
Opening
me
of
out.
the bid.
The turnover clause they have set up in such a manner.
Opening of the bid.
Opening of the bid is on, typical is on 21/7.
Now notice that cover to the first.
Take notice. Notice on both the repetition and the IR petition.
Correct.
Item 13.
180 ml. 180.
Oh.
Item number 14.
Wait, please. The
Seven.
revenue is challenged the order passed by the London six times.
29.
But the order is initial one, page 49, start from page 49.
See, 2 dates from
No. That's not possible.
The
Received the copy. The application form, they responded.
place he is a beneficiary of the order, so we
Yes.
have to submit.
Yes,
I'm the beneficiary.
yes.
Well, you are ready?
I'm ready. I'm ready.
No.
Because I'm going through that sister order. There is no question of law.
Oh,
It's
then you
a
are
based
ready.
on facts. I'm ready.
Oh, so without serving a copy, then
Yes.
we can.
Yes,
yes, yes.
Substantial question of law.
Yes,
There is the substantial question.
but the
Is
question,
he required to be heard?
This come from the first day.
first,
And
So before admission, whether he has a right of audience.
no, Lord, he has already filed his Wakalatnama. Therefore, I'm
I am
asking.
asking, sir.
Yes, that is.
The reason for asking is different. That's why I'm asking. Is he entitled to be heard?
After admission.
To show us what is the substance.
Yes, not the moot question is not the revenue raise. Not whether the not 123 of the customer has been complied with or not. 123 of the customer.
What is that?
123 is customer for not.
Custom section.
I have posted in my. It is not to see.
Custom section.
So, see. It starts in page 44 of my.
I have a book.
Yes.
Yes.
It is not.
Burden of proof.
Burden of proof in certain cases. Where any goods to which this section applies are seized under the act in reasonable belief that they are smuggled goods, the wording that they are not smuggled goods shall be in case where such seizure is made from the possession of any person, and person from whose possession the goods are seized
And if any person other than the person from whose possession the goods are seized claim to be the owner thereof also on such other person. In any other case, on the person, if any, who claim to be the owner of the goods so seized.
So it's a reverse burden.
Yes. So therefore, your lordship will see the judgment of the session and its finding.
Yes.
Lord, starts from this 49.
Relevant for portion.
Is relevant person the cast the finding of the tribunal. By taking in Lord 4 and 5 judgment, page internal page 67, paragraph 26.
Okay.
26 now. Internal page 67. Of the judgment.
It's 7. Yes. That's the finding he has made.
He says,
Lord, has satisfactorily discharged the burden cost on him.
We are of the view that appellant has satisfied discharged the burden cast upon them in law under section 127 custom. They have demonstrated that its position of the seized goods. On the other hand, the department has failed to irrevocably demonstrating that fallacy in the evidence
By the appellant.
appellant notice. Thus, for want of same, the seizure and the ultimate confiscation of 20 gold bar is not warranted.
So the findings goes that though the initial onus is upon him to prove, once he discharges the onus, then it shifts on the department to prove otherwise.
Right.
So see where is the wrong in the in the judgment.
Yes.
What can be-
If your lordship see the judgment, before lordship see the judgment, kindly see not the adjudication order which they have challenged before the tribunal. That is the issue. Your lordship see the order of the adjudicating authority. Then your lordship, I will show your lordship the point raised by the revenue. That starts from 115. Before Lord, I am just missing the fact. Otherwise, Lord, I am not your lordship. I am not able. Here is a case, Lord. The revenue department gold bar is seized while a person is not traveling from a bus. Lord, bus is been detected, and some gold bar is seized. Initial statement Lord says that somebody else is not the owner of the goods, and subsequently thereafter, Lord, this present person is claimed to be the owner of the goods.
Immaterial under section 123.
Yes.
Even a person from whose possession it is seized, obligation is upon him to prove. And
That is the blood case. That is the case.
What?
We have
There are
not
many.
Yes, we have not.
No,
Blood.
it was seized. Then
It was
he
seized.
says that he is not owner.
No, he initially says I am collected from somebody else and delivered to somebody else.
Correct. So
Later,
he's
Lord.
clearly a courier.
That is what his statement. Lord.
Correct. Sir?
Later, Lord, the present petitioner came before the authority after 5 to 7 days and claimed that I am the owner of the goods.
Correct. So he can. There is no difficulty.
Lord, after Lord, the statement recorded from the persons Lord, who has been cash sold by the department, then somebody else come the I am the owner of the goods.
Maybe so somebody who comes forward and says that I am the owner, then as per section 123, the obligation or burden of proof lies on him to prove that he is the
Yes.
owner.
Lord, now,
He has not committed any
yes.
offense under the act.
Yes. Lord, the initial seizure of 20 bars, Lord. Initial seizure of 20 gold bars. Lord, according to the revenue, Lord, it is a foreign goods.
Origin. So
Foreign
origin. Goods of a
foreign origin, Lord. But the person who was not cash hold, he stated that it was purchased from one person
and delivered to the another person. But subsequently, he has came up with the finding that I have purchased from somebody else, not the said person, and the name of the person who has been to be delivered. But he said we do not know the person. I mean the present person.
Difficulty.
So, let kindly see the.
Please consider a goods of a foreign origin is seized
Yes.
by a customer. They say, they believe
Yes.
that it offends the provisions of the customs.
Point of view. Yes.
The moment the goods are seized, then the burden of proof or the onus lies on a person. There are three categories of persons.
Yes.
One is a person from whose possession is recovered,
Yes.
or a person who claims that he is the owner thereof, then the burden lies on him, or any other persons in that regard. So either of these situations, if it arises, then the burden of proof lies on them. Immaterial that at the one point of time what he says, if somebody comes forward before the authority and claims that I am the owner, then it is his bounden duty to prove that how he got it, whether there was any departure from the provision of the act. It so happened that somebody else has imported after payment of the custom duties and whatever the duties leviable they were on, then he again traded it. These are the things that will come. We don't know. So it's a quality of evidence which has to be.
But according to the revenue, this smuggles goods.
The true smuggled goods, the goods are goods. Smuggled goods means the goods either it comes under the prohibited goods or a goods which attracts a custom duty or the duties to be levied thereof, having not paid, or through some other means it has been brought to evade that particular duty. Smuggled goods does not mean it's a spurious goods.
Correct. So therefore, my lord, in the Millard, he has not come up with the finding and placed some evidence that these goods are purchased from certain persons. And if you also find out from that invoices, Millard, all the invoices are printed, Millard. Printed invoice. But so far as the Millard foreign goods, it has mentioned the column. It is mentioned column here. Once it has been handed over, all this Millard is printed from, but only this so far as the pointing a finger by the revenue at this from the foreign goods or the local goods, it has been mentioned in the Millard pen, printed pen. I mean pen. So after Millard,
it is written, that's written in handwriting.
Therefore, Millard, it is doubted that it is not a goods which has been stated by the present
if the documents which they produce are in conformity with the law, and if it can reasonably corroborate the stand that every bit of the sections have been followed, then the burden shifts on you to prove that these are either the fabricated documents, manufactured documents, fraudulently obtained. You have not been able to prove anything.
No, Millard, we have proved. What? But we have proved. Try to prove, Millard.
One receipt is in handwritten and everything is printed. Does not really raises.
No, that is what one of the.
It raises a suspicion.
Suspicion.
The suspicion is removed.
Millard, we have recorded statement on 9 and 10% on these issues. And the each Millard person statement is not correlated to each other. And the document may Millard, according to the revenue Millard, the document may not be Millard in the name of the person. It is Millard, if your lordship see Millard,
what are those documents?
That is the Millard purchase invoices.
From whom?
From the Millard MMTC, and another is Millard.
Have you ever contacted them?
Yes, we have recorded a statement from both Millard the person concerned.
Have they said that this is not a genuine receipt?
That Millard, that your lordship finds.
Have they said that this is not a genuine receipt?
No, that has not been named. That has not been named in the person of present petitioner, present respondent.
Sir, asking you, sir, very simple way of very practical, may not be very relevant. Is from my common sense I am asking. A person who purchased the goods from a rightful owner, who has a right to sell.
Yes, ma'am.
If that person sold it again, is there any bar?
No.
Does it attract?
Absolutely, absolutely no. But here, my lord, what my lord he did, my lord. If your lordship see page 69, he has stated that Vikas Bullion Corporation is the seller. The name is Sri Ranwa, is mentioned. It is not the name of the Satish Kumar Subudhi, somebody else's name. He is claimed to purchase from the Vikas Bullion Corporation, but the name is appears not something else in the invoice. I've enclosed in the appeal memo. Let's see.
What is this?
Kindly see my lord, page 69.
Yes. Yes.
Now this is name Sri
Ruma or whatever.
and
Whatever.
the next place not Sri
Vishaka sold to Ruma.
Ruma.
Or
Then-
Pavitra.
Then Pavitra.
Yes.
Then
And
Milad
Prashad.
Prasad Subudhi, Parampur.
Yes.
Then Milad Prasad Subudhi.
Yes.
Well, therefore, Milad, these bills are not named the present respondent.
Yes.
Therefore, Milad, the claim of the respondent
What is
that
the name of the present respondent?
Milad present.
Prasad Subudhi. Prasad Subudhi.
Prashad
Subudhi.
Prashad Subudhi.
Yes. So therefore, Milad,
So the two receipts are also in his name. Subudhi
yes,
of 12 each.
12 8
Both of
and
12 each.
12 8. All other two Milad are not in their name.
Yes.
Other first two are not his name.
Correct.
So now your lordship,
So
I'm
he has showed at least 10 quantities,
yes.
10 pieces of gold bar out of 20.
20.
He could prove.
Yes. So now your lordship, kindly see, Lord, in the order of the tribunal, our Lord stands before the tribunal and how the Lord tribunal is giving this finding. That your lordship, I can persuade your lordship that
And how the Visakha Bullion Corporation he purchased? He purchased from MNTC.
he may not purchase Lord MMTC.
MNTC is the
Yes.
person.
Yes.
Who's the origin?
Is the person.
Correct.
Lord, kindly see, Lord, the brief facts starts from Lord page 15.
50.
Page 50 of the internal page 50, Lord Tribunal's order, internal page 2. Paragraph 3, Lord. Paragraph 3 and 4 Lord, most important. That will be tell about both suits. That based on the specific information, while keeping the
No,
surplus.
that's true. That's the story which you made out.
No, that is
Anyhow, now we have to see. The bills were in the name of Prashad Rao Subudhi.
Yes,
2 bills.
2 weeks.
And Ruma, UPRM or whatever, 1 bill.
And the statement,
Yes.
yes. Therefore, not the that in order not the recorded statement, but I don't think relevant because he has stated that I have handed over to somebody else for preparation gold or not. It's not relevant. Only the relevance is not the person concerned against whom the allegation is levied. That is important now. Paragraph 6, Lord, after considering all these deals and the statement, Yes. Kindly, my lord, take your lordship to paragraph 9. 8 and 9. That will not stand of the, if may I please not 8 and 9. Two paragraphs. Because all the goods will not cease from Satyendra Panda.
There is matter you have the question. That way, as you will be agreed, for the tax method, at least you take it to the other side department. License. This one. Something different. What you are projecting is different. You are projecting a half-baked defects. Where initially they produced this panda was telling it produce certain invoices which was not telling. Later on, when he comes forward to say that that was the by mistake in I am keeping the invoices. Thereafter, they gave us invoices of this bullion company. Then the bullion company, there was some variance that whether it was purchased from SBI or from the MMTC. The bullion company later on came forward and said that we purchased it from the MMTC. MMTC because they are opposed. MMTC because they say that they use in this USB branch. Yes. Because the SBI says that they never use it, they never sell. MMTC says that we sell it. Then MMTC told that we don't normally use USB or UBS or whatever. We don't use this, but still it is what we deal with it. And the bullion company has also come forward and also corroborated certain, the invoices indicating that yes, we sold it to them. If that be the position, the court has said that you have taken all these people, you could not.
But court milord is two ground milord, two ground they have rejected.
Once the MMTC has.
No, that is not it. That is not the question. Question milord.
What is the question?
No, milord, paragraph 17 milord. That is not the issue. Thereby milord the tribunal go against the revenue. He says milord the department has however discount this evidence on the following two grounds. That in a private sector, it is extremely easy to generate a computer invoice even in absence of sale. The word used in UBS on the copy of the MMT invoice tendered by the appellant during intermission was in effect.
No, this was your stand to disbelieve their evidence.
Believe because milord.
Now, when you are before the High Court, for the purpose of the substantial question of law, you should understand that every question of law is not a substantial question.
Correct.
It is those you show us that the even finding which is written based on certain logics.
Yes.
That does not raises a substantial question.
Milord, why milord I am saying?
Ignorance of the vital piece of our evidence. Then relying on a particular evidence which is immaterial, purposity. These can be a ground for the purpose of substantial question.
Therefore, milord, I am placing to pursue the lordship. I am placing paragraph 9. Paragraph 9, your lordship has already let's see. It is noted a casual glance of two copies of one and same document.
Sir, you are again I'm saying
no, milord.
The judgment has to yes, two copies they do not tally.
Does not exist a certified copy invoice received directly by MMTC, not UBS.
Sir, it is then wrong, sir. When the investigation, there were certain copies initially produced that raises a doubt. Later on, they produced a copy.
Yes,
of the invoice issued by the bullion.
Yes.
The bullion people were contacted by you.
Yes.
The bullion people, some dilly-dally, later on they say MMTC.
Yes.
You approach the MMTC.
Yes.
You want an MMTC and the bullion both confirm. We deal with the brand UBS, Swiss name. We deal with it. We have sold it. And the bullion company said we sold it to him. And this is my invoice which he accepts. Now there was a brand, UBS was written.
Yes.
They come forward and say that normally we do not use the brand UBS.
Your only difference is.
But they did not disown. There is one fact.
But
they did not disown that they never sold this particular space to bullion MMTC. Did not disown. And the bullion also did not disown that he sold it to him.
But the fact remember the certified copy of the invoice received directly from MMTC and the original is doubtful.
Sir, who can, if the MMTC says, yes, I have sold, can you raise a doubt?
Because
who is the authentic person who can say, it is a seller who can say, I have sold.
But the document is doubtful.
Maybe for one reason, if he comes forward and says, I have sold, what more?
That's why burden sits on you. It is disturbed initial chorus.
Yes.
Now burden sits on you.
Like section 102 of the Evidence Act. The initial burden lies on a person and it is always a shifting one. The moment the initial onus is discharged, then it shifts on you, the onus, to dispatch. Or you are dispatched. It says that you approach these two persons, later on thereafter you kept mum. You did not do it.
That is what the tribunal did not. So
You did not do it. Then what more?
You have substantial question. Yes,
I understand.
it is not simple question of law, which
I understand.
which gives us the jurisdiction.
But that is the only similar I have to
Which is what I'm saying. The problem is that
I cannot develop more because everything is everything is
if we can find that this goods entered into the country through some other means.
yes. But only the question of doubt is there, nothing.
Without the duty. Then you do that. You are correct. But it comes from a proper custody. If MMTC, which is the government owned company, actually, is a 100% government owned company.
Yes.
That is what I'm saying. It's 100% shareholding is.
But he will not ultimately he has sold the goods inside this.
So,
No, my lord, the question not, my lord, what is hardens me, my lord. The person from who is standing sees he's not the owner of the goods.
then one has to understand section 123.
Yes, ma'am. Yes, ma'am.
Whereas he goes to give this section applies under this act. In what the condition is seizure of the goods.
Yes.
Second condition is this seizure is in the reasonable belief that they are smuggled goods.
Yes, ma'am.
Is the third condition. First, it is seizure of the
Seizure.
goods. Seizure must be believed.
Yes.
And the third one is the belief is that it is a smuggled goods. Then you say the burden of proving that they are not smuggled goods is a reverse presumption.
Yes.
Shall be in a case where seizure is made from a position of any person, on the person from whose position the goods are seized.
Yes.
And if any person other than the person from whom the positions are seized claims to be the owner thereof, also on such a person.
That is the
So both.
that is last line is others. Last line is not others.
But go on.
No.
Who comes forward and claims that I am the owner, then the onus is on him to prove that that it is not his fault. What more?
But that is
Well,
like
this card. Fine, very clear.
I understand, but
Yes. This is what we are also the latter one of weekly and the same
same.
this company is
Another 25 minutes.
By contents is the evidence is doubtful that maybe recorded in this. Evidence which has been produced by the before the authority, my lord, is doubtful, and the my lord paragraph.
On suspicion.
Yes, that is what my assumption. Therefore, my lord, it cannot be.
That you might you particularly then have to say what is the substantial question of law.
Yes, it's not. I leave it to lords, but
Of evidence can.
Yes, yes.
Can form the substantial.
But so far as my lord revenue, my lord, it is my small request that is the and my lord paragraph 8 and.
That concludes of the Supreme Court. Was Santosh Najari. On a substantial question of.
Yes.
What would and what would not. And Santosh Najari.
Santosh रहते हैं on the particular
Just follow this by that is one section. Because the substantial question of law is
2001 SSC.
and it is followed. What is the reference?
Reference not.
2001.
3 SSC page 179.
2001.
3 SSC page 179. Santosh Hajari versus Purushottam Tiwari.
Neutral citation is also there. Neutral citation.
You think that is. Yes, yes, let me interpret one substantial question of law will mean. Consistently, that's a very, let's say, judgment, first judgment, it is not consistently followed. Even in case, 25 also it is followed. I believe the first judgment.
Yes, Lord, I am not standing the blame, Lord, but my submission may be recorded. That is what my request. Lord. Otherwise, I understand, Lord. I understand all these things.
Send it as a.
Yes, it's much better.
Neither that vote.
Item 18.
Director to operate reproduction. I pray one more week.
It says that every question of law is not a substantive question.
I pray to one more week to obtain instruction. Well, but in this, for the appeal, your lordship had directed, since your lordship had 169 D, whether notice have been served, or we had to obtain instruction on that. You had sent it just one, on Monday.
Keep it on Monday on the next.
Item 19.
Just the problem at the GST registration process.
RC.
Item 20.
Need vigilance. I have considered this on the ground of distribution manner. I have applied initial is manner. I have applied for the by beer shop, right? Annex of license for beer shop, right? Annex 1. Kindly see Annex 7. Page 27. The collector has received on 15/4/24 from the excise director letter, and it was forwarded. The proposal was placed before the government on 38/24 and 8/27 Annex 7.
What is the
Yeah,
date of the
as per
letter?
my- as
What
per
is the
the-
date of the letter?
Date of letter is 38/24. Just below my reference, Excise Directorate, just 2 line. Letter dated 15/4/2024. Got it, fine? Right, Annex 7.
Annex 7, you can page 26. So that is why we are confused with that. So I am unable
is-
to. We are referring 24/4/2025 or 30th of August.
30th August. 30th August.
24.
Yes, 24.
This page 26. That is page 26, Annex 7 is written in hand.
Fine. But that is my lord.
What do you find?
That is that reference for excise director letter number 15.
Where do I get a letter?
15/4/2024.
Oh,
Yes.
yes, that was, yes.
Next, it was sent the proposal to the government on 38/24.
Yes.
My submission, first submission before also that in discussion, and it was sent as per the rule 51 circular 13 that it shall be sent within 2 months. That proposal by the collector. Thereafter, your lordship kindly see that is.
How the discrimination.
I am going to that point. I'm going to that point. The collector shall, after recording specific opinion, forward the application on the other document and inquiry report of the inspector inside to the commissioner under intimation to the state government within 2 months from the date of receipt of the application. That is more than 2 months. Next, my lord, will also kindly come to Annex 6. Got it? Annex 6. Last paragraph, my lord. From the report of the collector, what you can do. On the report of the collector, it is revealed that the location of proposed site violates the restrictive provision rule 26 of the excise rules 2027 as one MSP public school at a distance 300 meters and one St. Xavier's High School 180 meters. Collector Ganjam has not recommended any relaxation of the restrictive provisions. Ballot of one sub, the license in favor of the Srimati, this petitioner, or Khata number so and in the name style, DN restaurant is sent to the government in excise department for taking appropriate action. There are kindly see Annex 8. My proposal was rejected on 24/4/25. But what I am saying, the kindly see the Annex 9. In this case, there are two applicants. My is the DN restaurant, other is South restaurant. Regarding South restaurant's concern, you will also find this application registered 9/7/24, and it was forwarded on 38/24. Just within time, you will also kindly see next page. His proposal idea was rejected. That you will also page Annex 10. The last paragraph. Preliminary inquiry into the application was conducted by the Inspector of Excise. The inquiry report reveals that proposed restaurant one shop is situated plot number so-and-so, Kata number so-and-so, Moses so-and-so, having is so-and-so. In the name style of Adikanda South, so and so, who has nominated son of so and lawfully attended holder by issuing a deed of power attorney. A registered rent agreement has agreed between the power of attorney and the applicant to use the proposed building.
I got it.
There, next page, my lord. Next page.
I got it.
In-
Schools are there.
Yes, in view of the public school, registered.
Oh, I understand.
Yes,
One of the school is the same school.
it is clear violation 26. Of the,
Then.
here, my lord, his application was considered.
Yeah.
Next, Annex 11. Last paragraph. Annex 11. That
Where?
blood.
The 11 is what?
Yeah, in view of the above last paragraph, the report of you, the report of you, the EC, Excise Commissioner, office dated 14/10/24 does not comes out any specifically with justified reason why the recommendation of Collector Ganjam was not considered. In view of the above, it has been directed that the proposal need to be reassessed afresh. You will reassess to and resubmit the proposal. Whereas my application is rejected, here yes, why not reassessed? After
Have you approached the government?
yes, I have stated.
No, have you approached the government of the excise department? He after this order
Yes,
of the excise commissioner approached.
yes.
Did you approach?
Because my proposal is rejected. That why
His proposal was also rejected.
yes, but he has his case is considered.
He approached the department, means the government,
Yes.
against the order of the commissioner. Have you approached the government against the order of the commissioner? I'm asking you a very simple question. You are
I have
relying
not-
on a order of the deputy secretary to the government.
Yes.
That means approach was made to the deputy secretary.
Yes.
Good. Or clear is a no. But he is sent to the government excise department. So they sent him. And he is in this case. In this case, what is done? No, it's the government of the ministry is Yes, sir. How can you do this?
On 27, allowed the other for reconsideration. On 27.
And here
on
we are given
70.
same draft.
70. On 24th, we are rejecting this.
Same draft. One of the school is same, St. Xavier's School.
Yes,
So,
but the distance of this shop in
sir,
respect to
if it
Lord-
comes within the offending distance,
yes,
it is immaterial that it is in a 100 meter or it is a 200 meter.
Right.
If the barrier is 300 meter, whoever comes, even 290 will come in the same line.
yes.
How can you dispense with?
But a license has not been granted to anyone, man.
Sir,
She may kindly
you have
appreciate.
rejected his case, whereas you have sent that particular another case for reassessment.
Reassessment because of the inconsistency.
So
Your Lordship, may-
the government should have said that both the cases be taken up together.
my lord, the subsequent case against which he is claiming parity, Your Lordship may kindly see Annexure 11 again.
Yes.
There, the proposed site.
Says that why the commissioner did not accept the proposal of a collector.
Commissioner in both the cases raised objection on the proposal of the collector in both the cases and recommended it to the government.
He understood.
My lord,
When both the cases were recommended to the government,
yes,
and it appears that both
yes,
have been denied by the collector on the ground of Rule 26.
Yes.
Then in one case, the government says reassess, you take a fresh decision why you have rejected the recommendation. And in this case, the government says, no, I am rejecting his proposal, no difficulty. Is it not a differential treatment? We are asking this question. When both the shops are within that particular offending distance.
Well, both the shops are at offending distance, but the other shop, they have given a finding that, however, they are not directly visible from the proposed site. That
Sir, here you have not given visible or not visible.
Yes.
There, that you
Here
have not
they have
said.
directly rejected.
So, how can it be done, sir?
I take
What take instruction is an apparent example of a,
records are apparent, but
of a discrimination. Apparent example. Both stands on the same footing. In one case, you did not cite any reason. And in another case, you just give a slightest of reason not visible.
discrimination can be claimed in consideration, but discrimination in the discrimination in award of license.
Yes.
The Lordship may kindly.
Yes. Again,
But
make a
but-
proposition of law.
my learned friend.
The
is arguing
discrimination
that-
can be made. What do you say?
But discrimination, he is claiming there is a discrimination in consideration of the application. Because the application was reassessed in one case, directed for reassessment in one case, and in his case, it has been rejected. But if my lord should look at the statutory provision, so far as that 500 meters, that is the objectionable area, he doesn't fulfill that. So in any case.
So the other. So the other.
Other the authorities may show it, or for
No,
that
sir.
reason it may be
He
rejected.
says
But
the-
can
the
he claim
report
parity against the provisions of the statute, my lord? Your lordship may kindly see 26.
Then if that is the proposition of discrimination, I am really at loss. The report of the collector and the commissioner shows that in both the cases, there is an educational institution within that particular 500 meter. Both, even we can go down 300 meter, within 300. One of these educational institution is common to both.
Yes.
The distance is hardly 60 meter or 70 meter. In his case, it is 180 meter.
The
In
other
that
is
case, it's
250.
240 or 50 meters. That's the only difference. There, he says, no, I do not accept. Why the commissioner has not accepted the report of the collector? No, you go and reassess. His case is outright rejected because it comes within Rule 26. When both are under Rule 26, how can there be a differential treatment? Now I'm telling you are talking about the consideration. This is called a differential treatment. What? Apparent example of addition.
Let me just, the lordship may grant me a week's time so that I can.
Unnecessarily, just it's a.
I'll just get
Give
some
another.
instruction why they have.
That's an apparent. Why they
So
have.
the records are
Because
apparent. I'll
If
just
those
verify
facts
with the
are, if
authority.
those facts are very clear, you can't deny.
The facts I cannot improve, my
That's
facts are there.
That's based on that.
Only with
The
respect to that.
the application for shifting of the online
Item 21.
The petitioner has filed a petition for a petition pending till now. The information order is so.
Already initiative has been taken by the IPO 111 Pepper, and he has written a letter to the CPC. He'll release that and he'll pass the rectification order.
By which date?
Within a week, he is telling me within a week he can pass that. So it may remand back to the, with the direction that the rectification petition may kindly be considered.
Consideration of the.
No, not that. They have taken steps to dispute it. It is stated by Sri Ajara. But it is probably. It is not that. Communicate the order to the participants, the petitioner.
Item 22.
That-
It is not. Prohibition and. Meet transaction and prohibition.
So the added minimum for withdrawal also.
Okay.
I'm seeking ability to find afresh with better particulars and adding a party to the.
Benami transaction now.
Benami transaction.
Yes, sir.
Number?
Yes, sir.
No, no, sir.
Item 23.
Okay. Our model regarding cancellation of.
Item 24.
That's recovery proceeding my lord, initiated under 246 my lord, without submission for demand of. Order annexation I as with 22 my lord. The second para they said that the order.
It is not so.
You know,
Long since it is passed, but not so.
also in this case in 2013 the order was passed 143(1)(a) and intimation was sent to them. In 2017.
He has not received.
You know, sir, after getting this letter, the small demand has been paid by him. And regarding a huge demand only, they have come before this honorable court. There's,
So they partially complied the order and partially they are challenging.
no, sir, at page number 23, the demand which has been shown, and that time it was not that order was uploaded in the net. And it's a gap of 12 years, what's it? Hello, I have last to page 16. Yeah, this is the demand against the assessing for different assessment years. And it's the 3 1. Since that
Bigger amount for the assessment year 13, 14, 16, 17. So he paid those amounts. But for this particular year, 2011-12, there is demand 24,45,000. See, under Annex 5 pilot, he made the representation for supplier that order to be appealable order. Since this is the appealable order, to file appeal, he asked for the appeal to order to be communicated. But under page 22, Annex 5, is the intimated that the order cannot be provided to you.
One,
It's not available since it cannot be downloaded. Once it is, if it was discussed in speed post, then there must be office copy in their file.
why you can't supply a copy of the order?
Your lordship, in this case, assessment return was filed and he claimed a refund. But the 26 AS was not matched at 28. That was a TDS.
Are you not
And-
going to, are you not supposed to give
We
them?
have served on 15/1/2020, 2013 lordship.
Where is
Page
the?
number 23, we had that output request on last date of service.
Where is that?
16, page number 23, last
There's a computer.
date of service.
Where do I get it, date of service?
So, this. Yes.
Date of service, which one?
It was
15/1/23,
13, your lordship.
2013.
And after, lots of changes have been
Service,
made in the
service
department.
by, service by. This mail, you cannot also see. At that time, software was something different. At that time, there was no email services.
It was sent, 2013 matter.
Newly introduced,
And even we cannot be served, in this, if only this copy we have which in our computer.
so in computer, the copy of the order must be there.
This, they have sent this one only, also, which has.
So where is the copy of the order?
The same has been provided to him also.
Do you have the copy of the order?
Only this order is
Do
available.
you have? This order is can't do. We'll have to show that where there must be an order. There must be an order. If it is not, they serve the copy.
I'll take instruction on this.
Start the assessment order with him to know the reason why you have raised that demand.
Because of mismatch of 26 years, I have received some.
I
instruction
understand,
from-
sir. There will be some order. There must be some assessment order which has to be passed. And that assessment order must have been communicated. You must have a copy also.
And that SSP only an intimation has been passed in this case. 143(1) lawsuit. Intimation order in the
Then
section.
how will you approach the appellate authority?
Appellate authority.
Lawsuit, it's a-
Very interesting.
You are misinformed.
Then how one can go for appeal? There is a provision for an appeal.
I'll be verifying this, my lord. But the lawsuit, it's a matter of 2013.
So what?
Order has been passed in 2013 and now it came.
But it does not appear that you are simply your system shows service of, but you could not produce a single document. Your system shows that order was passed. You could not produce a copy of the order. Then what to do? And he's saying that it was never served. He says that copy of the order was never made known to him.
I have not the case 24, my lord. In the web portal, there is no such intimation order or anything passed.
In your
Yes, seek it, sir.
curriculum. So, if you want to have the demonstration, concession, or then instruction. With regard to Annex 5. Annex 5.
We also we have the only processing details we are having with us only. That-
It's, the file of up to 6 years, generally the files are with the department. And that time computer.
So will you not keep the documents till 10 years?
Your lordship, it is 2013, now it is 12 years, your lordship.
Oh. Yes.
We have only having this process details only, your lordship.
On the next. The instruction, let him come. Yes.
Item 25.
Thank you.
Rectification also refused.
This matter that has happened.
Rectification is also refused. Annexure 5 is a rectification order. That means rectified or not rectified?
No, no.
Not rectified.
Concept actually rectification order was passed. But prior to that, there are some other cases, second one is that one demand order was passed for the year 2017 and 18. That is an annexures 1 university. And the relevant part is at page 30. The tax demand is reflected at 0. Page 13, 1 3.
Yes.
Tax is reflected as 0. Next you let's see at
Tax rate is 0.
Tax demand is 0.
Where is the demand 0?
It is 1 3. Only interest and penalty is
Column number 8.
That is page
That
13.
page 13.
Yes.
Column number 8.
Yes, 0.
Yes. Next you let's see that is the liability registered for that period, let's see 2017-18. That is available in portal. That is at page 20, let's see that is that starts at page 18. The relevant part is at page 20. There also tax is 0. Only interest and penalty is there.
Right. So
Then you see one amnesty scheme, the government has implemented one amnesty scheme. And under section 128A, let's see, because this order is under section 73, the petitioner applied for that to avail that amnesty scheme, right? SPL 02, that is the form. SPL 02, and that is at page 22. And because the tax amount was 0, so no payment was to make, and only interest penalty, that is a waiver of interest and penalty amount is. Then one so-called notice was issued. That is page 26. That is SPL 03 units. Pursuant to that so-called notice, let's see, the reply was filed asking for 4 weeks time, let's see, that is at page 32 years. That yes. That is 31 units. Starts at 30. 4 weeks time was requested. Then let's see at page 32. That was rejected. Entire application was rejected. That is annexure 4, that is under challenge units.
that's the ground of a illness of a mother.
Next year, let's see what has happened. That is the date is 9/6/2025. They have refused my application. The reason was stated as page 33. Application is rejected on the ground that taxpayer has not paid the tax amount. On the very next day, you let's see, page 34,
No, that you asked for an adjournment when?
that is a,
In the month of May.
yes,
So,
13/5.
so. And this order appears to have been passed in the, June.
Then 9/6.
They are not interested. The date
No,
for the proceeding.
no. Directly that was rejected. On 9/6/2025.
Rejected on the ground that you have not paid any tax.
Tax,
So amnesty scheme is not applicable.
Obliged university. The very next day, they have rectified their own order, that 2022 order, that is annexure 1. Unilaterally, they have. And the page 35,
They have
let's
tax
fine.
now.
Now
They have
tax is
determined
there.
the tax
Yes,
for the same period.
yes, yes. That was rectified by the authority.
No, that's page 17, Lordship, can listen, Lordship. Tax was earlier tax was there also, Lordship. Page 17, the detail order. Lordship.
This was zero at one point of time, now it is.
No, Lordship, what happened?
15,000 and something.
Page 17, the 73 order, Lordship, kindly see, Lordship. Page 17, 17.
After how many days?
No, Lordship,
No, that
on
is-
that 22.
That is annexed. It is
The
there in the
73 order,
annexure.
Lordship, kindly see, page 17. Tax was there, Lordship. What the assessing officer did, Lordship, is while demanding the tax interest
Page
penalty.
17, Page 17.
There is
One
the
seven,
annexure
Lordship.
units. In the annexure part, that was there.
In the detail order, the tax was there, Lordship. While entering in the credit ledger, the liability ledger, what the assessing officer did, instead of entering tax interest penalty, he has erroneously entered as interest penalty and fee. Subsequently, by taking advantage of that error, when the petitioner has applied for the amnesty scheme, the authority has noticed that error and also intimated, Lordship, kindly see the so-called notice as page 28, Lordship. The authority has admitted that Lordship, page 28, the so-called, Lordship, fourth line, Lordship. As per the original demand order, the correct breakup liability is tax of rupees 2,30,000 and interest and penalty. Inadvertently, the figures were wrongly recorded as tax 0, interest 2,30,000 and fee 23,036 in GST portal while creating demand. Although the attached annexure clearly mentioned the correct classification of the liabilities, the taxpayer, despite being aware of the inconsistency, didn't bring it to the notice of the department. Instead, the taxpayer opted to file Form SPL 2 to claim relief from interest and penalties under the over scheme without making payment of the actual tax amount of 2,30,000. So when they have applied for amnesty scheme, the authority noticed, and subsequently, during pendency of this of the SLP2, the authority cannot rectify that liability ledger. That is the reason authority, after giving time, thereafter they have rejected and subsequently rectified. Only the demand ledger, Lordship. Now, if the petitioner wants to avail that scheme, since the but my humble suggestion before Lordship that if the petitioner wants to avail that scheme, then tax liability was there, Lordship. Now it is also there. Your Lordship may set aside this rejection order, let him pay the taxes within 7 days and avail that scheme, Lordship, since the application is pending and he has filed application within time, Lordship.
Yes.
Yes.
In the error, the authority has also admitted the error, Lordship.
You deposit the tax.
Yes.
Within 7 days.
Yes. Because of these rejection orders, if he cannot now pay or avoid.
During pendency, he cannot rectify the demand order. That is why he has firstly rejected, then rectify the demand order.
Because of the rejection, now he also, the client also cannot pay and avail that limit.
As per order under section 73. Is to be deposited to Annexure 4 shall be considered.
That is the rejection order. Annexure 4 is the rejection.
That Annexure 4 is set aside. Then application, your application is?
My SPL 2, annexure 3 series, SPL 02, the form SPL 02 at page 20.
Well, item 26.
It's a option for covered by
The section 120
capital.
28 capital shall be considered.
Item 26 of
26.
officers are covered matter regarding 7340. Please.
27.
Same as 26, 73.
Yes.
Both, 27, both the cases.
Same.
Item 28.
Permitted to witness liberty units. There is some subsequent changes in the time alerts. I have to file a.
Right, you withdraw?
Yes, sir.
Both the
Which
cases.
is liberty units.
Yes.
Yes, sir. There's some subsequent changes in between.
Item number 30.
All the golden minor.
Delay of 7, I don't know.
Delay
of 7 days.
Serve the copy. Issue notice on delay application. Returnable after 2 weeks. Yes.
Item 31. Well, sorry.
My lord, I pray for not press. I'm finally better.
Not press. Not press. This is not press.
Item number 32.
Of the case as a very checkered career. If you kindly see the order dated first in the repetition. It is the order dated 30/10/20.
So.
And against this, SAP was filed.
Yes, immediately to remove.
Yes, that was there. Against that, SLP was carried. That means the parties, those who are not made parties, were sought to be indicted. In that appeal was dismissed. That I will pass on that order with other orders. Then Lordship kindly see the order dated 12/1/23.
Yes.
Right. Now then Lordship kindly see the order dated 17/7/23. Here, my lord, in 12/1/23, the State Council was directed to give the supplementary development. They have filed the appeal. They have said that till they are possessing the land, they are having their own land, own house, everything is there. It's there. I have got the copy.
I have not.
Yes, that is there. And my lord, I will pass on this because this is not.
One second, madam.
After review, my lord, I have appealed from party. Other party notice has to go, my lord. Moreover, government has directed to file additional counter appeal. I have not
This is only to linger the matter.
No, your writ petition is not maintainable. If the PIL, how you file for encroachment, they are encroacher, where they encroacher, they are collecting money from their encroacher, my lord. That is my counter. No, allegation, no, I filed on affidavit.
You have filed the affidavit, I have reported that.
On affidavit, they are collecting money from the encroacher, my lord. All the petitioner. Some of the petitioner have stated that virtually their signature has been taken. They have sent letter to the collector. Moreover, the other party notice has to go. Without making us party, my lord.
You appealed for them. You appealed for them.
Making submission. My lord, this court in review directed you make all the parties. We haven't made party.
You have filed the counter. We have
I
filed the result.
we will submit.
Government has filed the development of the fact.
Let you submit the submit. Let complete. One after another, it is not.
My lord, against the 20 encroachers, the eviction proceeding is on, and the Tahsildar Tangi has additional Tangi has sought police protection because there will be serious law and order problem in that Itilga area. So on that question, the matter is pending and all that. So, but added opposite party and concern regarding their status where they are encroaching, that people, I have to file an additional affidavit. No, these affidavits have happened 20%, I have already filed.
You see that. So, whoever may be.
So in that case, I have take further instructions of
How many encroachers are there?
8 to 27. 8 to 27. My lordment appeared in the review that
No,
I am passing on that.
How many encroachers are there over that land? Total encroachers.
Total land is, they have given the record of right, they have also given the record of right, around 3.5 acres.
And how many people are occupying?
Enclosure Miller list is there. May draw your file. Further to direction. Tahsildar has already filed the.
Mr. Mahanti, opposite party numbers 8 to
27.
27 are the
All enclosures. Yes. That document is there in the read.
beyond this.
That appears to be a 19 persons, but he says 20 persons initiation has been done.
Not that. It is not correct. He has not gone through the record.
Done, I am not.
You have not gone through the record. Kindly see.
That is the affidavit, but I am basing on the affidavit was filed by
Your
Tahsildar.
document we have
In the annex of done, he has said the details, who are the person, how much land they have in encroaching. That is the affidavit we have filed and the annex to done.
They have supported us.
So far, the other opposite parties who have been added after the review order, then regarding their status, I have asked for a report.
Please rectify your submission on the basis of the record.
No,
because
I am placing
please,
the
please,
report only.
let me
That's why I am saying that.
Let me clarify.
Take from the Tahsildar.
Let me clarify, my lord. Your lordship, kindly see the order dated 12/1/20. 12/1/23. They had already filed the counter. Further development was asked, and that further development they have already filed. And that is the document. Your lordship, kindly see. This is the document. This is the document I have received. That is flax sheet. That is flax sheet. You have filed. Other orders?
Sir, how many encroachers are there according to you?
Hello?
According to you, how many encroachers are there?
So far the Tahsildar affidavit is concerned, he's saying there are 20 encroachers.
28.
Encroachers.
Have you taken any steps against 28 encroachers?
For every order of eviction has been passed, for execution only we have sought for police assistance.
So you have initiated proceeding and culminated into an order for removal, but
Removal.
till
To
date
be
you are unable to remove them.
Yes, ma'am.
Any of those persons against whom you have passed an order for removal approach to a high court or to any other forum?
They had approached after this disposal of the writ petition that will bring to your lordship notice. That has been also disposed of. Because somehow they wanted to stall the matter.
I just wanted to cut it short. Just have a patience when I am asking all these questions. I just wanted to cut.
The fact that is why
No. The bottom line of this episode is very simple. If it is not in dispute that the land belongs to a Brahmin,
yes.
If it is not in dispute, correct? Then in that event, anybody who is occupying or who have constructed or whatever, they are an unauthorized and illegal occupant therein.
Yes, ma'am.
Then the law prescribes an initiation of proceeding against those, and then after affording them an opportunity of hearing, to pass an order for their removal. The removal order has already been passed as it appears. You are unable to implement. Right?
Yes.
How much police you require to implement the order? You have CRPF here. If your police is inadequate or not that competent to tackle the situation, then we can take utilization of the central forces as well.
Yes, ma'am. Additional Tahsildar has already to sub-collector. Today I was trying to contact the.
Sir, how long? This matter appears to have been taken out in way back in 2013 or 14.
14 order was passed.
And we are in 2025, more than 11 years have passed. How long one will take to
Give us 2 weeks time.
recover?
2 weeks time. I will talk to collector to provide force and all that for carrying out the eviction. Eviction order has already been passed.
Somebody who is also there and against whom no order for recovery or removal is passed, then we'll have to initiate a proceeding against them as well.
Yes,
We'll have to. You can't remove them in the garb of that.
No, that we cannot.
So go and restore that.
Let it come after 2 weeks. I will take proper
Restore it
instruction.
straight away. We will record that immediately. This is the position. The order has been passed. It has not been challenged. There is, if in the event there is no interdict or there is no order of restraint upon you, you have to proceed and you will have to remove.
Yes, ma'am.
So let's kindly have a look at page 40. Eviction of unauthorized encroachment made in village. Just a minute. Under jury. Just a minute.
Your tongue will come.
Jaripada RI circle and deployment of police force therein. This office letter number so and so dated so.
That is there, sir. That is what I
am pointing out. With reference to the subject cited, I am to intimate that about 33 encroachment cases have been initiated against the concerned enclosure for unauthorized construction and permanent structure on government land pertaining to plot number so and so, and these are the cases list they have given. 33.
What has happened to 33 cases?
Nothing has happened. This is the letter I am reading that this has been given in 2013.
He says that the order of removal. He says that the order of removal, final order has already been passed.
Already passed.
So the 33 cases, those which are pending,
not pending, no cases.
Has to be disposed of.
That is why your lordship. That is why the court has directed you file fresh counter affidavit disclosing the position, to specify the names. we have, one second, we have been added.
Sir,
Allow me to submit.
sir,
My lord,
sir,
I have.
I will hear you everything.
My lord,
Please,
I have appeared.
there are 3 questions I am
Well.
putting. Give me answer.
My lord,
Give me
My
an
lord,
answer.
I have
Let me
appeared.
put 3 questions, one after
Fine,
another.
fine.
Oh, give me an answer. Are your clients the occupant of that land
my lord,
which is
my
recorded as a
lord, my
voucher land?
lord, that is. My lord,
Is there any proceeding initiated against your clients?
my lord, they have never disclosed.
I am asking
My
you,
lord, I have
sir.
no proceeding, my lord. That's why the court has directed to give additional affidavit
Sir, just
disputing everything.
according to you, no proceeding.
No. And I have appeared.
Then only we will direct them to initiate a proceeding and bring it to its logical conclusion.
Let them file counter affidavit.
What
The
for?
court has specifically directed.
Sir, we will not keep this particular writ petition pending.
My lord, I have also.
If the
I
law
have-
says that they have to initiate a
My lord, I have
proceeding, they have to
appeared.
initiate a proceeding.
My lord, I have appeared for 1, 2, 3, 4, 5,
concluded.
7,
Oh,
8,
it's
9,
not
10,
concluded,
11.
sir.
I have appeared for.
Straight away, we know how to pass an order.
I have.
Let us see, we want to close it. We do not want show that there is a matter pending in the High Court and go on lingering. No.
My lord, after review is allowed.
Kindly give
I have
the
appeared for 12 opposite parties. Other notice has to go.
Why are you
We are not passing any adverse order against them. We are simply, sir,
Ma'am.
don't worry. We
Ma'am.
are simply saying that whoever is the encroacher of the said land,
Ma'am.
it is a duty of the government to initiate a proceeding. If they have initiated a proceeding, and passed an order for removal, if there is no appeal or there is no injunction order operating against them, we are directing them to implement that order immediately within a period of 2 weeks. If some of the encroachers against whom they have not initiated proceeding, we are directing them to initiate a proceeding against them.
But total 38 acres of land, my lord, in my counter affidavit.
Why will go?
My lord,
You admit you are the occupants. What is your right? Tell me what is your right? What is your right to remain on the land? Show us the deed of your title. Show us.
More than 30 years, my lord.
That means
They
tell me adverse
application.
correct. Adverse possession against the government land.
My lord.
Show me the law.
My lord.
Show me the law,
My
sir.
lord,
Let me understand.
My lord,
You can claim adverse possession
My lord,
against the government land.
I am stating my lord, but a vast population has been grown on 38 acres of land. School, colleges, hospital, temple, everything is there, my lord. I have stated in my counter affidavit.
Everything will go.
My lord,
Everything will go. Why you are?
it will go.
It is a government. It
That's
is a
up to the
government
government,
to take a call.
my lord. That is up to the government. In my counter affidavit, I have stated all these PIL, my lord, the PIL petitioners, my lord. Petition number 1 is that he is a agent collecting the rent from the giving by adverse possession, my lord. Petitioner 2 is also in there got possession of land through petition number 1. They are possessing the land. Petition number 3, 4, and 8 are encroachers.
They will go. Sir,
they may be come out.
Sir, what is a sauce for a gander is a sauce for a goose.
My lord.
No difficulty.
But
if they are, they have to go. Everybody.
All the read petitioners, they are encroachers, my
Oh, everybody.
They are
go.
collecting money. Since you did not pay, this PIL was fine. And after seeing the list, they have reported before the collector that they have procured our signature for filing the PIL money.
Sir, suo moto PIL can also be initiated.
Well, that is different. But that is
Different.
They have
So let us see when we found that the governments.
Left it to the government.
Yes.
Let them decide for all cases, not for the.
We are saying that wherever in the state any government land is enclosed,
That
it is
is
a
also
duty of the government to remove such encroachers.
In Tignath Panda case, my lord, Justice S.K. Sahu, It is OPL matter, my lord. PIL is not maintainable. It is up to the government.
Sure.
It is up to the government.
Yes.
And within that domain, since OPL Act is operating, it is a lengthy judgment and expenses. Filing. That was good. I have not received that additional counterfeit by the filed by the government. If that has been filed. घर कम घर देखना यार कट गया पाई दे तो बाबू तो मुड़ी है ये तो प्रश्न वाले मैं तो पुलिस से सुन लगा तो तो कभी तो पाई तो हम तो कुछ कम हो रहा है तो पाई
Sir, what for you cited this
Madam,
judgment
the
and
PI
made me to read,
Madam,
for
PI
10
is
minutes?
not maintainable, madam.
Is it one line from any observations?
So, she says that
Please, one line from this judgment you should. The court has gone, what we were proposing to pass an order has gone to pass the order.
well, I am also saying so, my lord. That view,
And you say PIL not maintainable.
well, same view may be taken.
Sir, there is a distinction
My lord,
between a same view to be taken and the PIL
I am
not
saying so, my
maintainable.
lord. I have stated each petitioner wise what their status. They are themselves enclosure, my lord. And total 400 enclosures are there in my counter affidavit. But they have adopted the selective method. Now, let me see in my counter affidavit, petitioner wise I have stated the PIL petitioners, my lord. Then, my lord, I have stated in my paragraph, they have stated 33 enclosures. No here stated names, nothing has been disclosed by the government. But there are 400 enclosures, my lord, in para 11 of my counter. Then thereafter review, this court directed you disclose everything, the present status. They have not, I have not received the counter affidavit till today, my lord. Then, my lord, 10,000 population has been grown and 200 voters are there. They have approached the selective method. So I stated in my counter affidavit that it is up to the government. They may take action by adopting the process of law. That is my counter affidavit. And these PIL petitioners, my lord, they themselves are enclosures. They are collecting money. And not only I have appeared for 12 to 15 enclosures made party in the review, my lord. Others, no notice has been done. Without making them party, my lord. How this court has taken a view that you make them party, they may be allowed to participate, thereafter may be passed. They have not solved the copy of contract. Notice has gone to the several opposite party till today, my lord, as per the direction of this court in review application. I say that let notice go. Government serve a copy upon me, that the matter may be had. And it is not a 33 enclosure, my lord. The total vast population has been grown. Temple, schools, hospitals, everything is over there, my lord. I'm
saying for a negative equality. It is
out of the record. What proposal, my lord? They are themselves enclosure, my lord. It is the domain of the government.
Nowhere in the record. Why are you saying all this?
What is they are enclosures. They want to evict us by selective method. It is the government to decide. In my read application, in that was disposed of, and this order.
Sir, I have heard you very patiently.
Well.
And I expect that something would be argued which is in consonance with law.
Well.
And not to be argued on a sympathetic consideration.
No.
Or by putting a blame game.
No.
It should not.
No, that is not my
When I said when the law is uniform, applied equally to all persons, it does not make any difference or a distinction amongst the persons.
My lord, 100% correct, my lord. I say that, my lord.
Take rest. Let the government take a call. If they have initiated a proceeding,
only submission, my lord.
That's all. Nothing more than that.
Of land, total 10,000 population has been grown, and temples are there, schools are there, everything has been grown.
It is a government who has to take whether they want to.
That let government take a decision. How to evict all the enclosures, not 33 or 20. They have till today they have not disclosed the names, not produced any records. Whether 33 or 20.
That is on the
not
record.
The record. Not filed by him, not by the government.
We have filed everything.
You have filed, that is why the court has directed to file fresh counter affidavit. That is why court has said you disclose. The government has not filed anything.
Every time he never concludes anything. He wants that matter should live.
No.
I am very immune, sir. I am very immune. Don't worry. I know how to tackle. So let me reach to a point when he exhausts the energy.
Well,
Let me reach to a point when he exhausts the energy.
my lord, I am adjusting my energy. I am doing my job.
No.
As per law,
No, sir. Still I'm
No,
saying you are agreeing with me. Why I say you are.
I am agreeing with my lord.
You are. Why I am saying that you are not. I am saying that whoever be there on the land,
My lord, I am agreeable to my lord.
they will take.
I am agreeable to your
That's all. Sit down. Sit down. That is what I am saying. Still you are continuing. I am accepting what you are saying.
Place on the record, my lord, with much difficulty, my lord, the review was allowed.
Sir, I understand. I appreciate your contention. Sir, please try to understand. If you continue, do not listen to the bench. Then you continue. I am sitting tight. I am just sitting tight. You continue.
I only wanted to place whatever I have stated in my contribution.
This is what you place. That you are not the select. They are acting against a selective process. The petitioners are also the encroachers. And if there is any action to be taken, it should be taken against all. We accepted it. We are going to pass the order. Still you are continuing, then what can I do?
Still I am trying to
convince. You have convinced more than what you wanted to convince.
I am not satisfied that you are.
That is the problem. That's why I say exhaust the energy.
This is the first time I have actually.
That is what I am saying. That you should know the pulse. This is you should know the pulse. When the court has accepted, then why unnecessarily you continue?
That you are actually not.
You think that the court is not understanding?
No. I failed to do my job.
No, you have done more than what is expected. So why you are? We are going to close it down. Should we pass after recording all these orders, which is... give me that judgment of the
My lord, the order had gone to the Supreme Court, then review now allowed everything. It is whatever there in the record. That I am giving. The data.
Which is
two sets of orders connected with the review, and they have filed another restriction that was disclosed of. Since that is not in this record, I am giving.
Also, which is one of the projects. We'll pass the order and further order to this. Don't forget.
That copies of the orders in review matter and other disclosures that once I have given. Two months.
This
2024 bracket 1 protocol page. I will call CAP.
And it is this judgment is reported based on
How well I would say this.
accepting your contention. Don't worry. Everybody will go.
Bye.
Everybody should go.
I think once we open that, a written note will show you that had a small date chart.
Before my running senior begins, I pray for the very short adjournment.
Very painful thing. The statute is staring at me. For last 10 years, the benefit of mining my area and working my area has been deliberately taken away. And the statute says that I have the benefit to 2030. They curtailed it to 2020 for no reasons. And 3 times the matter has been remanded to them. So I have spent a lot of time with litigation, and this matter now comes at least third or fourth time. Each time the council changes, each time there is a line in different benches, of course. This bench is just come to the first.
I am praying for only day after tomorrow. Let it be a fast matter in the least.
What for? What for? You want to prepare yourself?
Yes, sir.
You will argue.
I will ask. I will ask.
You wanted a time for preparation.
Lakshmi, then on Monday, your Lakshmi is
Monday.
top of the list.
Yes.
Item 34.
May I please, Your Lordship? I may be pardoned, I'm appearing online, Your Lordship.
Yes. What is the matter?
Your Lordship, in this petition, Your Lordship, I'm challenging the illegal allocation of the oil palm cultivation district, Your Lordship, while the memorandum of understanding signed between the petitioner and the government was still persisting, Your Lordship. Lordship,
Yes.
Next week.
Have you got the copy?
No, we have not received the rejoinder document.
Oh.
Your Lordship, the pleadings are completed. I'll serve the copy of the rejoinder, Your Lordship.
You serve the copy on OP number 3. 3. You have got the rejoinder copy?
Yes.
You
have paid.
No, rejoinder she has paid. So
Yes, Your Lordship. State has been served, Your Lordship. I'll serve it to opposite party number 3.
You serve copy on in the office of Sri Upendra Kumar Sam.
Obliged, Your Lordship.
what's that one?
Your Lordship is fixing a date, Your Lordship.
Just to serve copy of this. Mr.
Item 35.
Obliged, Your Lordship.
Lordship, this is related to blacklisting matter. But your Lordship, the blacklisting has to not only to loss to participate in tender, but also this is a permanent loss of technicality because I cannot participate. Number 3, it's a financial hardship and it's a civil death according to tender. So such a when the order is blacklisting passed, there must be consonance with the law and fair opportunity of hearing. And I am challenging 4 grounds. First, the one that the fair opportunity of hearing was not granted. Number 2, there is a double jeopardy. Once the tender condition provides for a penalty, you impose a penalty. You can't, for same by agreement, you cannot issue debarring for pass an order of blacklisting. Number 3, that the procedure, the guideline provides that these circumstances which need to be done only blacklisted pass. But they have blacklisted below 1 ground. So this condition provides that you have to file non-achievement of milestone and substandard work. They won, Your Lordship. This is 4 ground, Your Lordship. Your Lordship, I prepare a date that for consistency of Your Lordship permitted. Milord, your lordships, can you, permit to place, Milord? Okay, lordship. This is the impung order annexure 1. I have Milord annex, Milord.
Yes.
Yes, Lord. Your lordship, can you do impung order annexure 1, Milord? Page 23, yours. This, Milord, this provides, Milord, that I have not completed towards the order is, Milord, I am at first advancing the natural justice, Your lordship. So the order is past 30th March 2024, Milord. Lord, my contract was terminated, Milord. The date of termination, Your lordships, that is 15th August 2023, Milord. Milord, serial number 5 of the my date chart, Your lordship, page 3. Milord, this I have challenged, Milord, 11th September 2023, Milord. The so-called was issued, Your lordship, in serial number 7, Your lordship, 18th October 2023, Milord. Your lordships, the petition on 13th October 2023 made a reply the matter is sub judice. Lord, so kindly defer the not to blacklist, Milord. And your lordships allow the my prayer, Lord, that is 1st March 2024. The next serial number 9, Milord. Pursuant to affidavit filed by the petitioner on 2nd February 2000 to complete the work within the stipulated 8 months, your lordships direct to complete 8 months. Lord, Milord, in between the state referred us SLP, Milord, against that order. And I annexed that order. Your lords, the Supreme Court remanded matter. This in the termination main issue was remaining adjudication. Set aside, please to set aside the order of this honorable court, Milord. And the blacklisting in between, Milord, blacklisting order was passed, Milord, 30th March 2024. After more than 6 months of the so-called notice, without considering the High Court order and, Milord, the terminations, where they have imposed by blacklisting for a period of 6 years, Milord. 2 so-called notice. Even this period of so-called notice, the punishment has not been reflected in that order. Number 2, Milord, I not filed the detailed so-called reply because this is a blacklisting order. You have to give a fair opportunity of hearing. After that, High Court order, Milord, you have not pleaded, Milord. That is related to fair opportunity of hearing, Milord, which is required, Milord. Your lots of no Eurasian equipments, UNC technology, all these things has been second with blacklisting. Even oral hearing, some cases is required, your lordship, that has been, your lordship, I have. So this is the case, Milord, the fair opportunity of hearing was not granted when the so-called was passed on 18th, Milord, October 2023. Thereafter, subsequent development, High Court allowed to permit the work, and I a short time I file a so-called. They directly come to the in absence of so-called reply.
But that order of the High Court was set aside by the Supreme Court.
Yes, Milord. Milord, before Supreme Court set aside, prior to that they have blacklisted. Your lordship, the so-called notice was 18th October 2023. Your lordship allow, please to allow the writ petition 1st March 2024. The blacklisting order was passed 30th March 2024. Honorable Supreme Court, please to pass 14th May 2025. In between, Milord. So this fact has not been, and even they say in the so-called notice order that I have.
Yes. Yes.
Even in so-called reply, even order, they say that in absence of so-called reply, they say it is not satisfactory. In absence of specific reply, it is not satisfactory. You will also play the impung order. There is no. I only say that this is only to the matter is sub judice. You will also play one so-called notice.
Where is the order?
Annexure 1, page 23. You also. Whereas Milord, the after agreement, whereas the Vinodin infrastructure superclass contractor awarded work with following works. Number one, so and so bridge, number two, the work thereafter, even after several notice for persuasion, the contractor failed to achieve desired milestone as per agreement and did not complete the above work within the time stipulated, violating the terms of condition of contract. And 18th October, your lordship, tell me the so-called next, your lordship. 18th October, 2023, Chief Engineer, World Bank Project, Odisha, the so-called was issued, only that so-called there. And the reply of Vinodini Infrastructure was found not satisfactory. I only said the matter, I have not.
Where you are reading, I am unable to find.
Annexure 1, sorry.
I am at annexure 1. Yes.
Internal lines, 5777, lordship.
The reply was not found.
Lordship, 10th line, your lordship. In response to the so-called notice by letter dated, letter number so and so dated 10th October 2022, the Chief Engineer reply Vinod is not found not satisfactory. But the so-called was 18th October. There is a 1st March 2023. This honorable court pleased to permit the 8 months. They preferred SLP. They say this is not and before honorable Supreme Court order, they have blacklisted. And this is related to fairness of principle of though I have not given fully opportunity to present my case. Lordship, the procedure of violation, your lordships. Lordship, the order, your lordship, annexure 1, last line, your lordship. Last first paragraph, last line, your lordship. The ground that 6 years blacklist issue pursuant to CORAM provision, sub-rule C, rule A of Appendix 34 of OPWD Code, non-achievement of milestone on sufficient and imaginary ground in respect of both both mentioned contract agreements. Accordingly, the contract registration so is suspended and also participate in the ban for 6 years. To do business completely, I ban to do business. So, lordship, the rule I have annexed the guideline, and this is also part of the tender conditions. Annexure 21. Annexure 21, your lordship. Lordship, this is the so-called notice, your lordship, page 126. Lordship. 126, annexure 11. Lordship, subject notice for so-called blacklisting under Appendix 1. So only one constant non-achievement of milestone. I am placing the contents of the so-called, your lordships. I permitted to place paragraph 3 of the so-called notice starting on perusal. It is apparent that the progress work is very poor. Vis-a-vis on the target, but you have respond to take any initiative to expedite the work nor applied the said notice. It is clearly appears that you are not interested to execute and complete the work within the stipulated period, though you have allowed the extension of time up to 30 October 2020 by government works letter number so and so dated 3 June 2020. The bridge work could not be completed within the extended period. The superintending engineer Malkanagiri by letter dated 26 August 2020 issues another so-called regarding slow progress of work. Neither you have expedited the work nor you have applied for the EOT. Then your lordship, the superintending engineer division again issue another so-called notice where he stated that even though you have committed during contract management held on so and so dated 6/7/2020 in this to start the bridge by 2nd week September 2020 till November 2020, you did not take any initiative to resume the work, your lordship. Then page 127, your lordship. The superintending engineer division issue final notice by letter number 25th January 2021 to you with request to execute the backlog quantity of the work by engaging sufficient men and machinery with maximum working hours, as well as to achieve the target for completion of the above project. Otherwise, suitable action as per the relevant clauses of the agreement will be initiated for rescission of agreement, your lordship. The so-called, your lordship. It is proved that due to lack of interest to deliberate negligence of the above work could not be completed till date and could not be used for could not be used of general public. In view of the above factual matters, you hereby directed to submit your explanation within 15 days from the date of issue of so-called notice why the suitable action shall not be taken under the appendix 34 of OPW code and under clause 121 of the DTC, telling which it is deemed to be deemed that you have nothing to reply against these so-called, and accordingly the action has deemed proper will proceed against you without any further input. My reply, your lordship, kindly have the two course next page is the same so-called notice for two. The period of 6 years, nothing has been mentioned. Only they say action will be taken, your lordship. Lordship, then your lordship kindly the annexure 12, your lordship. So the penalty was imposed, my lord, for the pursuant to under clause 2BI, my lord. Total, my lord, your lordship, the bridge work, my lord, this with your lordship, annexure 12, page 130, your lordship. Another is also refined at your lordship. 131, my reply, your lordship. I replied that, my lord, this is only case is pending, my lord, not to proceed. There is no the complete reply to that, your lordship. And this honorable court, please to allow the repeats on your lordships. That order, my lord. The lordship, that is, my lord, the annexure 20, page 164. That is, after the 1st March 2024, the order, your lordship. So, because the 18th October, matter sub judice, your lordship, page 164, annexure 20, your lordship. The file is seeking direction to allow him to complete the work. In additional affidavit filed by the permitted place, paragraph 5, Mr. Chancellor and advocate who instructed contain the opposite party will have no objection if the petitioner complete the within work period of 18 months as indicated affidavit 2nd February 2024. In view of the above, the petition stand disposed of, directing the opposite party to permit the petitioner to complete the work within period of 8 months as indicated paragraph 3 of the affidavit. The order was passed, 1st March 2024, after the so-called notice. Thereafter, the state, it was set aside, interim order was passed, thereafter subsequently set aside, but the blacklisting order was passed, 30, the date of interim order is 30th March 2024. On and they are not allowing the two work, they have preferred against that order, and they are saying, they have not substantiated the work not completed. So this is related to the violation of principle of natural justice. They have not giving fair opportunity of hearing this fact in the order. Number 2, the violation of guideline I am saying that which your lordship, annexure 21, your lordship.
Yes.
Your lordship. This is the guideline of Codal Operation, your lordship, that appendix 34, your lordship. Where the chief engineer of a department may blacklist a contractor with the approval of the concerned administrative department on the following grounds. I am in C, your lordships. They have blacklisted in C. Constant non-achievement of milestone on sufficient and imaginary grounds and not adherence to the quality specification despite being pointed out. My lord, my humble submission, there must have been violation to one hand. The guideline provides a thing to be, my lord, it has to be firstly not, my lord, to not achieving milestone. Number two, their quality, my lord, compromising the quality, because when there is a violation of two conditions, then the petitioner will be blacklisted. And my lord, my humble submission in this regard, in the so cause notice, impugned order, even counter affidavit, the allegation is slow progress of work. So my lord, when the guideline, a thing to my humble submission, the principle will apply when things to be done a particular manner, they send to be done, my lord, because this guideline provides they have to violation of two. Lord, so my humble contention before Lord, submission before this honorable court. So this could have been, if my lord, the could have been effective hearing, this could have been dealt by the honorable by the authority, my lord. So this was not been done because the guideline provides violation of two, your lordship. And in this guideline provides, my lord, page 160, next page, your lordship. There is a recommendation and shall due inquiry and then so cause notice, which is dealt by another high court by this honorable court regarding OPWD code, your lordship. Page 167, your lordship. Next page, your lordship.
Yes.
Well, the division officer shall report the chief engineer if his opinion mean the above wrong has been committed. Above wrong has been committed, my lord, the contractor on receipt of some report, divisional officer, chief engineer shall due inquiry and if considered, issue so cause notice to the concerned contractor who shall turn on
Where are you reading?
Sorry, page 167. Same guideline.
Oh.
In top, your lordship.
Oh.
The divisional officer, your lordship.
Yes, I got it.
Yes. Your lordship, that the divisional officer shall report to the chief engineer if his opinion any of the wrong has been committed by any contractor. On receipt of such report, the divisional officer, chief engineer shall make due inquiry and if consider issue necessary so cause notice to the concerned contractor, whose turn shall furnish his reply, if any, within fortnight from the date of receipt of the so cause notice. Thereafter, chief engineer satisfied that there is a sufficient ground, he shall blacklist concerned contractor with the approval of the administrative department. After issuance order of blacklisting to the said contractor, chief engineer shall intimate the chief engineer for other administrative department the registration authority as provided under Rule 4 of the PWD Contractor Registration Rules.
I got your point.
Yes,
this is what you wanted to say.
Yes, your lordship. Your lordship, kindly there is a format, your lordship, kindly annexure page 162, 8, your lordship. The annexure 1, your lordship. Page 168, your lordship, the part of guideline. Now, this is the format, my lord, my humble submission, your lordship, serial number 10, your lordships. This is a checklisting of the blacklisting. The number of only so cause one is issued. Lord, I file a reply that thereafter subsequently, Lord, they have only honorable high court order. After 6 months, they have blacklisted. So my humble contention before this honorable court. First of all, my lord, your lordship, the impugned order, violation of principle of natural justice. Number two, the guideline provides that if there is a violation of two conditions, then you can't violate, my lord, one. I cannot be punished because blacklist is a severe punishment. And number three, my lord, I recently, my lord, honorable Supreme Court in the matter, recent, my lord, just Vishwanathan with first, that mere termination of violation of agreement, a person cannot be blacklisted. And here you have imposed a, my lord, penalty. So, my lord, my humble son, once you impose a blacklisting penalty of crores of rupees, and under the same agreement, you can't, my lord, blacklist him because, my lord, this is a double jeopardy, my lord, my humble submission. You also can want to listen to. Let's see paragraph 26. Paragraph 26 is related to, sorry.
Yes.
Your lordship, paragraph 26 was, lordship must have been. So these say that for the ordinary breach of contract or person concerned who raise bona fide dispute, my lord, the cannot be blacklisted certain number of years, your lordship.
Yes.
So the, my lord, so we are here, your so cause notice and other thing, you have halted the terms and conditions. But and regarding your lordship, double jeopardy, my lord, I shown that clause, my lord, your lordship has last time said that the clause was not visible. I make it typed copy, my lords. There's a number of clauses for if not completed, not achieving milestone for compensation, my lord. That is, your lordship, page 44 of the lead clause 2A, your lordships. And second clause, your lordships. But the clause 3.12, lord, page 91. 1 point page 90.
Yes.
Your lordship, clause 2A provides, my lord, then your lordship, clause page same, my lord, type copy, page 92, your lordship. Next page, kindly, sir. Clause 2, 1.2. As per the amendment of the para 3 of the OPWD code volume 1, before acceptance of the tender, the successful bidder will be required to submit a work program and milestone basing on the financial achievement to complete the work within the stipulated time. And in case failure on the part of the agency to achieve the milestone, liquidated damage will be imposed. Then your lordships, kindly turn next page, your lordships. The 2.1.3. 93, your lordships.
Yes.
Lordship, to ensure good progress during the execution of work, the contractor shall be bound in all cases with the time allowed for any work exceed 1 month to complete 1/4 of the whole time allowed under the contract has elapsed, half of the whole of the work before half of the whole work time allowed under the contract has elapsed, 1/3 of the whole work before 30% of the whole work time allowed under contract has been elapsed. Then 2.3 last line, clause 2.3 compensation. Compensation for a delay. If the contractor fails to maintain required progress under clause 2 of the contract to complete the work and clear sight on the before contract or extended date of completion, he shall, without prejudice to any other right remedy available under the law, the government on account such breach, pay as agreed compensation amount calculated at the rate stipulated below as the superintending engineer whose decision shall be final may be decided the amount of tendered value work every completed date months as applicable that the progress remain below the specified clause 2.1 of the contract or the remains incomplete. So lordship has said that there is an imposed penalty. One, my humble submission for lordship, once you impose a penalty, you can't, under the same violation, you cannot same agreement, you can't blacklisting because without violation of guideline. Lordship, the blacklisting clause also, that same clause is page 94 of the brief that that is clause 121, your lordships. That the tender condition. Annexure 2, your lordship. Page 94. The same page 194, your lordship. Annexure 2. It's a reproducer of OPW report. Lordship, clause 121, your lordship. A contractor may be blacklisted as per the made on appendix 2 rules. The blacklisting contract letter dated so and so similar. Constant of non-achievement milestone on sufficient and imaginary grounds and non-adherence of specific and specified being pointed out. Because first violation they have provided compensation, my lord. And the second violation, my lord, there is if the regarding first violation they already recovered the, my lord, compensation and other. The second violation there is no, my lord, agreement provides for compensation. This is a, my lord, very, my lord, substandard work which related to, my lord, which is public interest. For this reason they have caused the Lordship, your lordship know that the Eurasian equipment, the leading judgment, my lord, that if the lordship, I permit one paragraph. So the case 5, paragraph 12. Under the, it's related to blacklisting. Under Article 298 of the Constitution, the executive power in India and states shall extend the carrying on the any state and to acquisition of the holding, the disposal of the property and the making of the contract any code. The state can carry out the executive function by making law or without making law. The exercise of such power function trade of the is subject to Part 3 of the Constitution, Article 14(6) of equality before the law and equal protection of the law. Equal opportunity should apply to the matter of public contracts. The state has the right to trade. The state has thereby the duty to observe equality. An ordinary individual can choose not ordinary individual can choose not to deal with any person. The government cannot choose to exclude person by discriminations. The order of blacklisting has the effect depriving a person equality of opportunity in the matter of public contract. A person who is on approved list is unable to enter into the advantageous relation with the government because the order of blacklisting. A person who has been dealing with the government in the matter of sale and purchase of material has a legitimate interest or expectation. When the state acts the prejudice of a person, it has to be supported by the legality. Then your lordship, kindly paragraph 19, page 6, your lordship. 19 and 20. Where the state is dealing with the individuals in transaction of the sale and purchase of the good. Two important factors that are that in individual is entitled to trade with the government and an individual is entitled to a fair and equal treatment with others. A duty to act fairly can be interpreted as meaning duty to observe certain aspects of rules of natural justice. A body may, under the duty to give fair consideration of the fact and consider the representation, but not to disclose to those persons details of information in its possession. Sometimes duty to act fairly can also be sustained without providing of opportunity for an oral hearing. It will depend on the nature of the interest to be affected in the circumstances in which power is exercised and the nature of sanctity involved. Paragraph 20, your lordship. Blacklisting has the effect of blacklisting has the effect of preventing a person from the privilege and advantage of entering into lawful relationship with the government for purpose of gains. The fact that a disability is created by the order of blacklisting indicates that the relevant authority is to have an objective satisfaction. Fundamentals of fair play require that the person concerned should be given an opportunity to represent his case before he is put on blacklisting. And your lordship, in a case of criminal case also, your lordship has please to observe in next another UMC technology I have annexed, your lordships. Start from page 8. Paragraph 13, your lordship, 13 and paragraph 13, my lord. Paragraph 13 is page 15, your lordships. Lord, here is a case that UMC technology where the criminal case also, my lord, they was registered, my lord. Lordship, paragraph 13, my lord. At the outset, it must be noted that if the first principle of singular jurisprudence, that a person against whom action is to be taken or whose right or interest are being affected should be give a reasonable opportunity to defend himself. Being the affected should given a reasonable opportunity to defend himself. The basic principle of natural justice is that before adjudication start, the concerned authority should give to the affected party notice case against him that they defend himself. Such notice should be adequate and the ground necessitate action of the penalty action proposed should be mentioned specifically and unambiguous. Your Lordship, can you see next paragraph? Paragraph 14 and 15 related to blacklisting allowances. Specifically, the contest of blacklisting a person or an entity by the state or state corporation, the requirement of a valid, particularized, unambiguous so-called notice is particularly crucial due to severe consequence of blacklisting and the stigmatization that accrues to the person equity being blacklisted. Here, it may be gainful describe a concept of blacklisting and graveness of the consequence occasioned by it. Blacklisting has the effect denying a person an entity to privilege opportunity of entering into the government contract. This privilege arises because the state who is the counterparty in the government contract, and as such, every eligible person is to be afforded an equal opportunity to participate in such contract without arbitrariness and discrimination. Not only does blacklisting take away the privilege, it also tarnishes the blacklisted person reputation, brings a person character into question. Blacklisting also has long-lasting civil consequence for future business in respect of blacklisted person. My lord, I saw that I lost my other things, my lord, my turnover and the technicality. Then you will see paragraph 15, your lords. In the present case, the appellant has submitted the serious prejudice has been caused due to corporation order blacklisting. Several other government corporations have now terminated their contract. The appellant prevented from the participating in future, though the impugn blacklisting order was in fact limited to the corporation. The impugn order was in fact limited to the corporation Madhya Pradesh regional. This domino effect, which can effectively lead to the civil death of a person, so that the consequence of blacklisted travel beyond the dealings of the blacklisted person with one particular government or corporation, and in view of thereof, this court has consistently prescribed strict adherence to the principle of natural justice whenever an entity is sought to be blacklisted. Your Lordship, please to pass, even not remanded, your Lordship, this is a case of criminal case, the similar. Lord, paragraph 21. What's the paragraph 21, please? This is thus the above discussion, a clear legal position emerged.
I have gone up to Sheikh Ahmed judgment. The conjunction, disjunctions, I have gone up to that judgment, Sheikh Ahmed.
That related to this conjunction disjunction that
I have already read it. That's why I said I have gone up to that. I have seen that those blacklisting and all the concept.
And the other things to be done in particular when the provides to partner, that is my humble sense. And one another judgment, your Lordship says Techno Prince versus Chhattisgarh textbook, where this Honorable Supreme Court recent judgment, also pleased to hold that mere termination and validity of agreement, you can't blacklisted. And so cause has been passed, stage of that is serial number 5 judgment, is page 69. 46 start from page 46, Justice Pardi was judgment, your Lordship.
Eurasian 33, you are trying to.
Yes, Lordship. But that is
34 as well.
Yes, Lordship. Page 69 is start. Paragraph 34, your Lordship. 34, 37. Your Lordship.
I have seen predetermined mind.
If predetermined is to visited the yes, Lord. Yes.
Yes. Yes. You are appearing. No.
Existing in the present case, the fallout of the rescission of the contract, which was the subject matter of the writ petition before this honorable court. And an interim order was passed basing on certain affidavits that was carried to the Supreme Court, and the Supreme Court said the court cannot rewrite the initially granted stay, and said that the court cannot rewrite the contract, and remanded the matter to be reheard. So that writ petition is pending. That is a separate. That writ petition is also pending.
This is regarding termination. The termination where this honorable court allowed the 8 months, honorable Supreme Court remanded to reconsider.
Yes.
That's matter.
That matter is pending. Now, so far as that rescission of contract, that was neither touched by the High Court nor by the Supreme Court. That still subsists, my lord, so far as that order is concerned. So far as blacklisting is concerned, but this is not an ordinary case of violation of the contract. Here is a case where adequate opportunity was granted to the petitioner to complete the work even after rescission of the contract till 2022, which can be borne out from the averments made in the counter affidavit, which are relevant to the issue.
Yes.
So, Lordship, I kindly see. So far as the conditions stipulated in the OPWD code as well as the conditions stipulated in the contract, my friend has already indicated before the court that page 94, 121 clause, so the OPWD code he has already.
If I correctly understood, his line of arguments are
yes,
that he is not deviating from a contract. Rather, he is relying on a contract and he sought to give an interpretation that the manner in which you have proceeded, both in blacklisting him, is not coming really from the clauses of those agreements. His first contention is that when a blacklisting is to be done, a show cause notice is sine qua non. Before that, the divisional manager has to do certain acts and things. And then once you have received the reply, by one stroke of pen, you cannot say that it is not satisfactory unless you give them an opportunity of hearing. So merely giving a show cause notice does not absolve you from acting in fairness and adhering the principle of natural justice. According to him, the natural justice demands that in blacklisting, you'll have to give them a personal hearing. And you'll have to record. This is first. Secondly, he says that you have blacklisted him under clause C, which has twin conditions. And they are intertwined with each other. They cannot be segregated. Your order of blacklisting is based upon one component. According to him, one component will not do unless both the components are there. And that is why he is using, he is arguing that the word and means a conjunctive word, and therefore you cannot segregate. It is not or disjunctive. That is the crux of their argument, nothing more than that.
Yes, Your Lordship, I kindly see that total provision, that is.
Sorry, the third argument he has advanced that when there is a provision for a penalty, and you invoke that provision of a penalty by imposing, you cannot blacklist him. There cannot be a double penalty or a double jeopardy, what he uses the word, but he says that he cannot be condemned twice for a same act.
But that argument, so far as double jeopardy.
But what about blacklisting clause C and one liner not satisfactory? What do you have to do? Forget about the fourth argument. What about this two argument?
That we have explained. Your Lordship may kindly see para 13 of the counter affidavit.
Yes, what you have said.
Para 13 to 16 are very essential. Lordship may kindly see.
Yes, what you have said.
It is allowed, it is humbly submitted that as per the commitment as well as the revised work program submitted by the petitioner, it was allowed the extension of time up to 36/2020. Submission of the petitioner to the effect that
That I have already read. That you say that despite the extension having granted, his performance was absolutely unsatisfactory. He could not meet the requirements within the time bounds. Does it come within the ambit of this clause C and next clause? What he's saying is that definitely it may come under the constant non-achievement of milestone on insufficient and imaginary grounds. That it may come, no difficulty, but the clause C says not only that, and non-adherence to quality specification despite being pointed out. Since there is no reflection of this anywhere, so this invocation is wrong. That is his argument.
So far as land of natural justice, which my lord is asking for, that no natural justice was followed, he was not given, although he was given a so close notice, but he was not allowed to be given a personal hearing to participate in the process of his consideration towards blacklisting, and that is concerned. But in a recent judgment, the Honorable Apex Court, that is 2022 volume 4 SCC 393. Which is a case from this Honorable Court. In fact, there the Honorable Court observes at para 20. I'm sorry, I could not get a copy, but I'm just placing it. So far as findings recorded by the High Court that blacklisting order was in breach of principles of natural justice is concerned, it is to be noted that blacklisting order was passed after issuing a so-called notice which the respondent contractor was called upon to reply and so-called as to why he be not blacklisted. A detailed so-called notice was issued with specific allegations to which the respondent contractor submitted a detailed reply. After considering the allegations in the so-called notice, considering the reply, And also by considering the material available on record, the order of blacklisting was passed. We failed to appreciate how in such a case, the blacklisting order can be said to be in breach of principles of blacklisting.
Now, question is that every decision is to be read in the context of a facts or a special facts involved there. We do not know because here is a case where you have not assigned any other reason except one line. They're not satisfied. There, the authority must have given a detailed order. We have to just find the parity of those facts.
Your Lordship,
Don't go simpliciter by somebody who just
Your Lordship may kindly see.
pass on to you some judgment.
No, that judgment I have referred, but Your Lordship may kindly see annexure 1.
I will again, page 23.
Well,
Page 23, impugn.
well,
That 10 lines. Just description.
10th line.
In response to show cause notices issued by letter number 44375 and 44374. Dated 18/10.
Give me that judgment. Give me your tab.
The reply of so and so was found on not satisfied. Over.
but that is, I don't dispute that because saying that not satisfactory, but if Your Lordship will see the opening lines of that order, may I place it, my lord? Whereas
No, that is the consideration of his reply. It's up to his reply.
Quality has been compromised that this person was dead. This,
Kindly see annexure 30. What was his reply? Although the case which was cited, that may be a case where the detailed reply has been submitted.
Have you seen that judgment which you are relying on? That was a case of a construction of a bridge or a flyover that was there despite the extensive reports or instructions being passed, no quality, the quality work was being adhered to. 10 meters of a junk that fell. One person and several were injured.
Died.
One person died.
Yes.
And several injured. There was a detailed inquiry and the report was given. The report was under active consideration of the government, and thereafter the finding of fault that the contractor has done this, it was initiated. And there was a detailed discussion in the rejection also. All these facts were reflected. Argument was advanced that it's a single offense or a first time offense. No blacklisting. That was also ruled out.
There also the person concerned submitted a detailed reply to the so-cause. Well, Lordship may kindly
No,
consider
there is a
one
distinction. There, it was on the basis of a government report, and the tenet of the order is that while rejecting his and blacklisting, all these things were considered and were reflected in the order.
Your Lordship may kindly see annexure 30. Annexure 30.
In your decision, show me apart from 10th line any other consideration which you have done.
Well, what was required to be considered? Your Lordship may kindly see annexure 13. What was his reply? At least he can.
Reply was not very candid. He says that their matter is sub judice before the Supreme Court. High Court. So please, in view of that, and I think he has been granted an extension of time also, and therefore, in that view of the matter, you cannot proceed on that basis.
Can that be considered as a reply? You have been so caused.
One thing. You have said that you have been delaying the project.
Yes, he should have explained
why. Please. What more, sir? You are a lawyer.
Yes.
A litigant approached the court and was benefited by an order. Court says that I am extending a time, 8 months time, I am giving you, complete it. He is within that period of 8 months. If a show cause notice is given that you have not completed the work within the time frame, he will definitely say, this is an order of the court where I have been permitted a 8 months time to complete the work. 8 month times have not expired. I will complete within 8 months.
And here the so cause has been issued for blacklisting. Your Lordship may kindly appreciate.
On what ground?
It has never been asked that why you could not complete the work. He has been issued with a so cause that because of so and so reason,
now
you have not been able to complete the work.
Then it comes.
Why you shall not be blacklisted.
Then it comes the another ground that how you justify this particular ground C. What is your reaction? What is your reaction to clause C? He has highlighted on the word and.
Para 11, you will see, para 11 of the counter. This is also a case of construction of the bridge, which could not be completed within the time frame. Despite repeated notices to the person concerned, to the project concerned.
When you have set out a grounds of blacklisting, can you go beyond that ground? Is the first question. And the answer is very clear that you cannot go beyond that.
That's part 34. 34.
34. Yes. Secondly, if the grounds you have taken says that these twin conditions must exist together, can you blacklisting on one condition? That's the most pertinent question. Yes, sir. Founder is saying. No, how can it? It's a pure question of law, sir. Is on the interpretation of a statutory provision. How a statutory provision is to be interpreted.
Yes.
It's a pure question of law. It does not require any
provision.
Constitutional
Two conditions have to be satisfied simultaneously.
Yes, this is what he wanted to say.
It cannot be
And
considered.
admittedly, you have taken one condition as a ground. It is not undeniable.
Ajit Singh case where the 5 judges bench also your lordship same however next page 25 and is
Sometimes this can be or like Article 304A and B, which was decided in this court, upheld by Honorable Supreme Court in 9 judges bench. Constitutional, there. Disjunctive. You have done many cases in taxation, entry tax matter. Article 304A and B.
But here is for one part they have recovering compensation. Already recovered.
No, that is the fourth. You have raised 4 points. He has to answer. He has answered the principle of natural justice by citing that judgment. Saying that once show cause is given, reply is there, that means it has been followed. Let us understand. But so far as this clause C interpretation,
But they have to be in conjunction, not in disjunction. Even at certain times, Harmonious reading
interchangeable.
leads to absurdity. Then this can be or. So twin condition cannot exist at one time. Then that end can be read as or. But here it is not the case.
Here the my lord. My
No, we
lord.
are accepting your.
This is my brother is saying that these two words, and or, are interchangeable depending upon the particular special facts. Like the word shall and may are also interchangeable. Sometimes it makes it more mandatory, sometimes the directory. So there are tools and the well-recognized principles of interpretation of statute. So there is no difficulty.
And even in my learned friend rightly point out, even counter only say that the on achievements of milestone. So because notice counter notice
Order.
Yes, Mr.
If allow the 1 day time till tomorrow, I will address on this 34C only. Tomorrow. 34C only. That conjunctive condition, whether the other conditions I
I
have.
think in division bench we have decided.
This is not similar division bench decided regarding this similar. The lordship there was the blacklisting, but the no and or not is the subject matter.
I was party to that.
And perhaps in fact, your lordship that judgment is confirmed by the Supreme Court. Your lordship. Same OPWD code, your lordship, sir. The RAP style, your lordship, that is status before appeal. This is OPWD is mandatory. Or RAPs, but
This is on what principle?
This is the violation, your lordship, kindly the blacklisted even submitted a false document without any notice and even
what is decided herein?
Here that my lord paragraph 24.
What has been decided?
There is no the not had been submitted. There is a
What
violation
paragraph?
of paragraph 24.
24 it does not contain.
Sorry. Raps. I am placing the raps.
Raps.
Or raps, sorry.
You are giving me this copy. I do not know what is this.
This is what two order of this.
What has been decided there? This judgment.
That Chandan Singh is on reason.
Yes, reason.
Statement of reason.
Yes, Lordship.
That we are not.
Your Lordship, and that judgment, my Honorable Chief Justice, as your Lordship, kindly add the paragraph Miller. The paragraph 9, your Lordship.
Where is that raps?
The raps, that's why.
No. Chandan Singh.
I just raps out.
No. Yes, let him come ready. Tomorrow or day after tomorrow?
The day after tomorrow, I have some difficulty personally.
Tomorrow?
Tomorrow first, your Lordship, first.
Yes.
Try to go village Miller. Tomorrow first. Your Lordship already had.
No. Tomorrow. For further hearing. This is the full code. Now at 4:40.
These are in the lines of reason. Raps and the other the lines of reason.
Have one these are all the hearing matters. There are all, so it has to go in line. Next, do not give list 2 hearing matters in a day. More than 2 hearing. Only 2 hearing matters.
36. That's simple one.